And
So
Tapan Bhattacharya.
the matter is listed as to be mentioned on the prayer made by the Council for the State for correction in the order dated 13th May 2025. Council for the State submitted in the cause title and in paragraph 2 of the order dated 13th May 2025, the name of the non-advocate appearing for the state has been inadvertently recorded as Kunal Acharji instead of Kallol Acharji.
With Tapan Bhattacharya.
Huh?
Along with Tapan Bhattacharya.
Tapan Bhattacharya name is there already. In view of the above, in the cost title and in the paragraph 2 of the order dated 13 May 2025, name of the state shall be read as Kallol Acharji instead of Kunal Acharji. This order may be incorporated.
I'm grateful.
And be treated as the part of the order dated 13th May 20. Next. Yes.
Section 21C, 25, 29 of narcotic drugs and alcohol.
Who is for the state? You?
Union of India.
Who is appearing? It's not here. Yes.
My lord, petitioner is in custody for 11 months and 19 days. Independent witness. My lord, no eyewitness, my lord. No videography, my lord. The contraband has been seized from the house of the present petitioner. All contraband has been seized from the house of the Japi Boshe, my lord. The FIR, my lord.
Where is the page number?
Well, on the last occasion, your lordship was pleased to give us liberty to file an exception. This is the copy of it.
Have you served the copy?
There is there's nobody to the NCB.
My lord, in page number 5, my lord, I have also stated in my petition, nothing has been incriminating article has been seized from the present petitioner house, but from the house of the Jaki Boshe. Every and my lord, in a similar case, my lord, a judgment has been passed, my lord, page number 20, my lord, starting from my lord, in the division bench of Honorable Justice Joymallo Bakshi and Gourango Bakshi, my lord. My lord, in the self-same circumstances, my lord, bail has been passed.
11 page is page number 6, paragraph number 16.
Page number 25.
Page number 25, paragraph number 16.
We have considered the material on record. There is palpable violation of dated order dated 22/6/2023 failing to undertake videography of the seizure of narcotics from the petitioner. There is also no independent witness to the seizure. Petitioner has made out a prima facie case with regard to the possibility of false implication and has rebutted the statutory restrictions under section 37 of NDPS Act.
But where is the state?
This is the NCB.
So nobody is appearing. No junior of Mr. Majumdar? Pass over. No. Pass over, I will call. 11 o'clock. Yes.
Another matter where Union of India is the respondent, lot. DRI happens to be the seizing authority in this matter.
Item number 3.
Yes, Mr.
Yes. Who is appearing for the state? You?
I am appearing on behalf of the DRI.
You are appearing for?
For DRI, Directorate of Revenue Intelligence, Department under Union of India.
may I, my lord, take one humble indulgence, my lord. My lord, in this matter, my lord, I was instructed to appoint a senior, my lord. I have talked with Mr. Joy Chaudhary. My lord, today he is returning from Darjeeling.
Hmm.
My lord, if time may be given. Lord. If not, my lord, I am ready with the brief to argue before your lordship.
Who is for the Union of India?
Mr. Konik is appearing.
He is telling the time is only for the DRI.
Yes, yes, yes,
Total.
yes, yes,
Both.
yes, yes.
Yes.
The opposite party is Union of India through the DRI separate colony.
Separate.
এ তো
আমাদের ইউনিয়ন অফ ইন্ডিয়া বলেই করতে হবে।
Okay, not today.
My lord, will it be appearing on Wednesday, my lord?
Uh, as per the prayer made by the council for the petitioner, let the matter appear on 21st.
21st.
Next. Yes.
But I'm for the statement.
Lord, allow me to refresh your lordship's memory, my lord.
Have you taken the instruction?
Yes, Lordship.
Yes. What is the actual thing?
Lordships, first of all, Lordships, I beg your Lordships kindly rectify my name as because in the earlier order, my name is appear for the petitioner, my lord, kindly be rectified. And there is, what is?
Why you persons are not giving the list to the my court officers?
No, Lordship, we are giving Lordship.
So by petitioner or by.
Yes, Lordship, we are
So why it
mentioning
is-
we are the state, but unfortunately it is mentioned the petitioner, my lord. Arjun and myself are both.
Why क्यों हो रहा है ये गलत? तो कुछ नहीं मालूम रहता. When you are accepting the slip, you are not seeing who is appearing the petition. They are writing the petitioner or the state item number. While accepting the receipt, you see. Yes.
Lordship, they are plea to sending the sample for delay, no, my lord?
Hmm. Not delay. There are contradictions in the even in your document itself. Kindly come to the investigation note, page number 16. Last order you have not gone through.
Yes, Lordships.
So what the court has asked for. Kindly
Lordship,
come to the investigation report.
yes.
Got it?
Lordship,
Then
just a minute. Lordship, I asked the IO and the charge sheet has been filed by the second IO. And the part of the first IO, they send the sample due to sample is sent later on, your lordship, it is admitted fact. And
later on.
yes, later on. But the sample was intact, your lordships. As and when.
1412 sent the exhibit S1 to the director FSL,
Lordship.
SDCR and RL. Correct.
Lordship.
Kindly come to the investigation note 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th line. 14/12/2023 sent exhibit.
Yes,
Correct.
yes, lordship.
Then thereafter, on 6th January 2024, IO has collected the certificate of correctness. Correct.
Lordship.
Now kindly next page. Report. Laboratory received on 22nd February 2024.
Lordship.
Which is correct. What instruction you have taken?
Lordship, they are saying that due to mistake they have done it. Lordship.
What? When actually it was sent?
Actually, report sent lordship February, lordships.
February. So what you have sent on 14/12? What you have sent on 14/12?
No mention, lordship. Either they are knowingly doing all these things or they, even I have gone through the entire CD lordships, but I don't found any, why they are sending the delay or for the preparation for, nothing has been mentioned in the CD. It's true, my lord.
What is your good name?
I'm Shubham Ghosh.
Shubham, Mr. Shubham Ghosh, learned advocate appearing for the petitioner.
Abhijit Sarkar.
Mr. Vijit Sarkar, learned advocate appearing for the state. The petitioner has filed the present application under section 483 of Bharatiya Nagrik Suraksha Sanhita 2023, praying for bail in connection with Pradhan Nagar Police Station case number
Can you do receipt?
859 of 2023, dated 17th October 2023, under section 21C with small c, /22 small c, /27 capital A, and 29 of the Narcotic Drugs and Psychotropic Substance Act 1989 and 1985, corresponding to CR within bracket NDPS case number 95 of 2023, pending before the London Special Judge NDPS and the London Additional Session Judge Second Court Siliguri. Counsel for the petition submit that the police has registered the above case against the petitioner, sole petitioner, na?
Yes. So
Accused sole against the petitioner on 17th October 2023 for the above alleged offences, on the allegation that the narcotics have been seized from the possession of the petitioner. Since the arrest of the petitioner, the petitioner in custody. Counsel for the petition submitted, the police has completed the investigation.
Lorships.
Completed
And
the-
already one examination has been completed and next date has been fixed on 23rd May.
completed the investigation, charge sheet has been filed and charge sheet has also been filed and one witness has also been examined. And as such, there is no chance of absconding of the petitioner from the instant case. Police. Learned counsel for the petitioner have brought to the notice of this court to the investigation note submitted by the investigating officer dated 8th April 2024, wherein it is mentioned that on 14 December 2023, the exhibit was sent to the director SD and SDC and RL and subsequently in next paragraph, it is in next line, it is mentioned that on 6th of January 2024, IU has collected the certification of correctness of the inventory. Learned counsel for the petitioner has also drawn the attention of the report submitted by the State Drugs Control and Research Laboratory, wherein it is mentioned that the State Drugs Control and Research Laboratory has received the narcotics on 22nd February 2024. When the petitioner has brought to the notice of this court, by an order dated 15th May 2025, this court has directed the prosecution, directed the learned advocate appearing for the state to clarify why this contradiction report has been filed by the investigating officer in the investigation note. Today, when the matter is called for, learned advocate appearing for the state submit that on inquiry, the investigating officer has informed the learned advocate for the state that inadvertently the date has been mentioned in the investigation report. Full stop. Considering the above facts, this court find that the investigation report is contradictory, which reveals that the alamat were sent to the CFS to the SDC and RL on 14th of December 2023, but certificate of correctness of the inventory was received only on 6th of January 2024. Considering the above, this court find that the petitioner has made out a prima facie case to come out from the section under section 37 of the NDPS Act. Accordingly, petitioner may find bail of rupees 20,000 with two surety of rupees 10,000 each, with the each out of which one surety must be a local, with the satisfaction of the learned court of
Lord,
Special Judge Poxo Court, comma, learned NDPS, comma, learned additional session judge, second court Jalpaiguri. If
Lord,
on bail,
Siliguri. Siliguri.
Siliguri, yeah. Siliguri, if on bail, comma, the petitioner shall appear before the learned trial court on each and every date of hearing, and he shall not hamper or tamper with the evidence.
Lordship.
Yeah.
Intelligence Lordships, my objection kindly be noted, and I am citing one ruling that the voice is sent later on, but the it's intact. as my-
CRM so disposed of. Next.
My lord, objection might kindly be noted, otherwise
ऊपर जो लिखा है ना क्वालिफाई by mistake full stop उसी में करो. Learned counsel for the state submits that the narcotics seized from the petitioner is commercial in nature and case is at the stage of evidence, and at this stage if the petitioner is released on bail, he will hamper and tamper with.
obliged, your lordships, obliged.
Item number 5.
Yes,
There are violation of the ADPS.
what rules?
Rules of 2020, my lord.
Huh?
Rules of 2020.
हाँ.
There are 14 men. Expedient states, the chemical laboratory shall submit its report to the court of magistrate with a copy to the investigating officer within 15 days from the date of receipt of the sample. Provided that by the quantitative analysis requires longer time, the result of the qualitative test shall be dispatched to the court of magistrate with a copy to investigating officer within the said time limit on original copy of the test memo, and in the next 15 days, the result of quantitative test shall also be indicated on the duplicate test memo and sent to the court of magistrate with a copy to the investigating officer. Nothing has been done. Madam. Kindly come to my dining page number
18 and 19.
19.
18 and 19, my lord.
19.
18 and 19, both inclusive, my lord.
He is relying upon 19. Para 10. Yes.
Further course of investigation and petition before Court of Judicial Magistrate Passport Siliguri, 13 West Bengal 27/3/24 was filed for certification, correctness of inventory and sample of the seized drugs. According to the sampling, the seized drugs and articles were carried out in Court of Judicial Magistrate First Class on 28/3/2024.
Correct.
Subsequently, learned magistrate certified the correctness of inventory of seized drugs on 21/3/2024. During the process, as per the direction, it was certification done on 21/3, and the sample was received by the laboratory on 1st of April.
Where you can find
Next, overlap, my lord. Overlap, my lord.
Overlap and also in the chemical exam.
1st April for chemical examination. Yes, then 14.
Chemical examination. Says that it was received on 1st of April 2007.
Received on which paragraph?
Lab number.
Yes. Correct.
The certificate and they send the report on 14/5/2012.
Correct. That's all. What has been seized from you, your possession?
That is called
Metmorphin.
metamorphosis.
Huh?
Metamorphin of commercial
Metamorphin.
quantity.
What is the quantity?
Above 50, my lord.
50 is the commercial quantity. And
69 something.
69. And the thing is that
Hmm.
when it was seized for
When you have been arrested?
For about 1 year, I am in custody.
When you have been arrested?
26/3/2024.
26/3
Lordship.
on the date of FIR.
And they were,
But just let me check, my lord.
no, not on the date of FIR. He was not arrested from the spot. He was arrested on the next day.
When you have been arrested? sir?
26/3/2024, my lord.
26th.
26, my lord. Paragraph 7,
26,
page 18.
And what is the stage of the trial? Charge sheet filed?
No.
Complaint is filed?
Charge sheet filed.
Charge sheet not filed?
Charge sheet.
When charge sheet filed?
Charge sheet filed on.
Where is the charge sheet?
Charge sheet has been filed, but neither it has been delivered and not the charge has been printed.
Charge sheet not supplied?
No. There are several dates of the 5 days, of the last 5 days, it has not been supplied. I have said that. Charge sheet has been filed on
29/2024.
4. But till date, the copy has not been.
Where is that?
Lordship, I find a seal given by the
Where? Which
special court on the first page, page 15.
page?
15, my lord.
Oh, yes.
Seal.
11/12/2020. 20 September 2024.
There was no independent witnesses also.
Where is the,
To
where is the Caesar?
These has not been annexed, my lord.
Not arrest. Yes.
Lordship, just for a indication to your lordship, this is the 4th application brought up by the petitioner. Last, it was rejected in the month of February.
Month of?
February 2025.
Where is the order?
Lordship. 4 to, if I'm not wrong, my lord, 4.
Where is the order? You have enclosed the order?
I'm trying to decide on merit. On getting the level.
Eighteen to my lord, page 12.
Page 12. Sole accused?
So like,
Yes.
so lordship, since 18 to 2025, nothing new has come up which we can term as supervening circumstances. Lordship, the main grievance of my learned friend is that CFSL report was received by the court on a later date,
Yes.
then mandated by the rules, which are directory in nature. My lord, I would request your lordship to go one step further. Let us assume a condition where a charge sheet in an NDPS case has been submitted before the concerned court without the CFSL report. Now, then obviously the question that will come up is whether the accused becomes entitled to bail because CFSL report does not accompany the charge sheet. In our case, albeit a little bit late, but CFSL report is accompanying the charge sheet. My lord, this question has been answered by the Honorable Division Bench of the Calcutta High Court in the judgment of, in the case of Ananda Burman versus State of West Bengal. The division bench led by Justice, Honorable Justice Devanshu Bhasak has answered it. My lord, Subhash Yadav has also been discussed here.
Yes.
My lord, each of the paragraphs are important because their lordships have taken the pain to discuss caten of judgments. And
Yes.
relying on Dilip Tarafdar's case decided by a coordinate bench of the Honorable Court, their lordships held that no.
Not the correct position.
Not if charge sheet without CSFL report is nonetheless a charge sheet. And when that is submitted, the right for bail is extinguished.
So they are the king scenarios.
Mr. Pal, when you submit.
Just
I said-
our senior is, you all, what is going on?
Now, lordship, the only grievance that he could raise, though my lord, I would again once again submit, this plea was available to him when the earlier bail was rejected by the coordinate bench. He did not raise that. Now, recently Supreme Court has opined that even in criminal cases, there is a res judicata in both ways. So my lord, what is the new ground that he is taking?
Okay. Yes.
Yes, my lord. That is number one. That is a provision which has to be, whether they have sent the qualitative result, that is also not done. Not 15 days provision, they didn't send the within 15 days. And if they fail to do that, they have to sell the qualitative result to the court of the IO. That has also not been done.
Yes.
So that is within 1 month also, and this, they have stated in he does not have any criminal antecedents. There was no monetary transaction, all these things also been stated in the para number, I have stated.
Okay. So in
Only
total,
one line, my lord, and I don't need to mention, but section 37 needs to be liquidated. Otherwise, bail cannot be granted.
There was, I know, here the thing is that scenario.
what is your good name? Mr. Aruna Bhopal. Aruna
All.
Paul. Learned advocate appearing for the petitioner. Learned. What's good name, sir?
Sudipta Majumdar.
Sudipta Majumdar, learned senior advocate or
DSGI.
ASG. You are appearing for the ASG. ASG is appearing for the state. Full petitioner has filed the present application under section 439 of the Code of Criminal Procedure, praying for bail in connection with Special Court NDPS Act at Siliguri within CR within bracket NDPS NI in connection with CR NDPS case number 22 of 2024 arising out of NCB Kolkata crime number 5/NCB/KZU/2024 dated 25th of March 2024 under section 8 within bracket small c read with section 22 within bracket C of NDPS Act 1985 pending before the Special Court NDPS being CR case number 22 of 2024. Counsel for the petition submit that the petition was arrested on 26th of March 2022 and since then the
24.
24
Lordship.
24 2024 and since then the petitioner is in custody. Fully counsel for the petition submit that the investigation has been completed, charge sheet has been filed, but till date charge sheet has not been supplied to the petitioner. And thus there is no chance of expedite trial. Fully counsel for the petition further submit that the investigating agency has violated Rule 14 of the notification issued by the Government of India dated 23rd of December 2022, wherein it is provided that the chemical laboratory shall submit its report to the Court of Magistrate with a copy to the investigating officer within 15 days from the date of receipt of the sample. He submits that in the present case, the sample was sent on 27th of March 2024. The certificate of correctness of the inventory was issued on 28th of March 2024 and the same was sent to the laboratory on 1st of April 2024. But the report was submitted on 14th May 2024. That is more than 14 days. That is more than 14 days. 15 days. More than 15 days. And as such,
That is April and it is big.
more than
One whole April and the May 14.
More than 14 days.
more than 15 days, and as such, the petitioner is entitled to get the bail. Police. So per counter and ASG appearing for the state submit that this is the fourth application filed by the petitioner. Initially, the petitioner has filed an application before this court on
One of the first ejection was on
before this court
2/12/2024.
on 2nd December 2024.
Then Mother 23/7/20.
But the same was rejected.
23.
No. 23rd of July
Lordship,
2024.
I stand corrected, Lordship.
23rd of July 2024, comma 2/12/2024 and 18th of December 2025. and on all occasions, 2025, 8th of February 2020. Yeah, 8th of February 2025. And on each occasion, the bail application filed by the petitioner has been rejected. Counsel for the Leonard ESG submits that in the present application, he has not shown any change of circumstances as to why the petitioner has filed the present application, though on the earlier 3 occasions, this court has rejected the bail. Leonard ESG further submit that it is not the case of the petitioner that the report has not been filed along with the charge sheet. Even though if it's not filed along with the charge sheet, in terms of the recent judgment passed by the Honorable Division Bench, dated in the case of Roshan Kumar Yadav, dated 2nd May 2025, the petitioner is not entitled to get the bail. Had the learned counsel for the respective parties peruse the materials on record, this court finds that the petitioner has not made out any case to come out from section 37 of the NDPS Act, and already the division bench of this court has rejected the prayer for bail, and this is the 4th application, but this court did not find any new ground in the present application. According CRM census is rejected.
Obliged, my lord. এগারোটার সময় দুটোতে লর্ডশিপ had fixed item number 2 at 11.
हाँ? ये ला
Whatever.
कौन सा कॉल किया? Which matter you called, sir?
6,
Okay, after this I will.
like.
Yes. Who is appearing for the 6?
I'm for the state, my lord.
Yes. Who is for the petition? You? Yes. September 2023.
My lord, by para number 3.
Para number 3 of your application. How much time your application is been rejected? 5.
My lord, nothing is only paid to the government. My lord, because recently, my lord, the contract was LLB seized on 30th September 2023.
Yes.
And after an inordinate delay of 2 months, 1 week, that is 68 days, it was changed to the laboratory for examination. Whereas in the act, in the rules, in the recent judgment, everywhere it has been stated, it has to be sent as soon as possible. And most surprisingly, the sample will reach the laboratory in Kolkata after a week. It is only a same. Number 2, this Mother can come to my number 16, madam.
16. Yes.
The contract was seized on 30th September 2023. It is
Correct.
filed here.
Correct.
And now date of receipt 13/12/2020.
Correct.
That is the it was the end of 7/12/2020.
Whether there is an application for extension of time. That is the main ground. If you are not taken that ground, now how you can take the ground at this stage?
My lord, moreover, my lord, charge sheet is submitted, my lord, and thereafter, my lord, trial is in Wales.
Yes. Yes.
It is
So it's as per your case, seizure was made on 30th September. Correct. And the material was sent to the laboratory on 13 December 2023.
yes.
Correct, received. And the report was submitted on January 2024, when the charge sheet was filed.
Charge sheet was filed after that.
Where is the charge sheet?
Well, charge sheet filed on, my lord, 31/2024.
13/1,
30th January
30.
2024. 30.
Yes.
Well, the thing is that delay is of 68 days.
Ah.
So what is the reason? There is no explanation, there is no change of custody, nothing has
Okay.
been explained, my lord.
Okay.
And
My
there-
lord,
it has been by the Supreme Court, it has been repeatedly stated the what in this delay may, the content, there may be contamination in the samples and the season.
Hmm.
So 68 days, there is very large delay, my lord.
Where is the PW1 evidence? Your
One evidence is not annexed, my lord. PW2 is there.
where is the PW1? PW2 you will annex. I know why you annex the PW2. But where is the PW1 and evidence?
I am not relying on that I am not annexed, my lord. PW2 is there. That is, now one more thing is very important, my lord. It has been stated that it has been, the article has been seized from the rented house of the petitioner. But the house is different, nowhere they will find their address is there.
Good defense
But
during
no,
cross examination.
And the landlord.
But trial
landlord-
is in well,
LLP, which the landlord, his deposition is there. They are stating.
Oh, PW2 is the landlord.
He's stating that they were not my landlord, they were not my tenant.
Yeah.
Number two, they have stated, categorically stated, my signature was taken at the police station.
Correct.
CSW1, my lord, deposition completed, CSW2 deposition completed, CSW3 is, my lord, fixed for on 11/6/2025, my lord.
Yes, then
My lord, kindly comes to page number 17, my lord.
Judgment 17. Yes, your landlord. Hostile. Yes, then
I have stated.
he is the Caesar witness. Landlord is the Caesar witness. Yes. Where is the Caesar witness? Who is the Caesar witness?
He is one of the two independent. He has stated that Vikram Jha was not my tenant.
Who is the PW1?
Peter, who one of the complainant.
Give
police officer.
the copy of the evidence of the PW1.
But power. is a Caesar witness.
Copy of-
Not brought.
And the last line, cross examination, my lord.
Yes.
I wrote my signature at the police station on plain paper.
Correct. Good.
I do not.
Who is
I
the
do not know Vikram Jha.
who is the another Caesar witness?
That is someone Hemraj. It has been stated in the this position.
He was examined.
No. Only
No.
two witnesses have been examined, my lord.
This complainant and the one of the Caesar witness. When next date is fixed on
Next date is fixed on, my lord. June.
Hemraj something.
so 11 June is fixed for whom?
Hemraj.
CSW3.
CSW3, my lord.
He is the witness for his examination.
Yes, CSW3 minus.
So I am fixing a matter in the month of after June.
My lord,
Let the PW the other Caesar witness be examined and bring the witness of the
my lord, kindly consider because this
okay.
because
Yes, what is
he's not the tenant, my lord. He's not the tenant. The landlord is stating nowhere they have annexed his address. Their address is given. That is the Gurung Basti. That is the different thing. There, the ID card also showing. And there was delay. This delay was not explained. There was other things also, manipulation. Like in FIR, the date has been mentioned differently.
Okay.
It has been stated-
Yes, what is your submission?
Moreover, my lord, trial is in well, my lord. Deposition of PW1 and 2 is completed, my lord. 3 is fixed on 11th June, my lord. The commercial quantity, huge quantity, my lord.
How many
2000
witnesses are there in as per
my
the
lord,
charge sheet?
total 15, my lord.
15.
Yes, my lord.
Last witness was examined August 2024, my lord.
So thereafter what has happened?
They cannot produce an witness.
You not file an application for bringing the witness. Not wait for the learned
That is
judge.
the prosecution job also.
Yes.
They may not have any witnesses, my lord.
Sense appearing for the petition. What is your good name?
But now,
For now, Paul and advocate appearing for the petitioner. Yes, what is your good name, sir? What is
My
the
lord, Aditi Shankar Chakraborty.
Aditi Sangar Chakravarti under PP or
Additional PV, my lord.
additional PP and additional PP appearing for the state. Full list. The petition has filed the present application under section 439 of the Code of Criminal Procedure for grant of bail in connection with Pradhan Nagar PS case number 7/8/2023 dated 30th September 2023 under section 21 within bracket C/22 within bracket C/27 capital A/29 of the NDPS Act 1985 pending before the London Special Judge NDPS Siliguri. Will the counsel for the petition submit that the petitioner was arrested when he was arrested? Petitioner was arrested.
30th
September twenty
Petitioner
twenty.
was arrested by the police on 30th September 2023. 30
Madam, 30.
30 September
09
2023.
Yes, madam.
2023, and since then the petitioner is in the correctional home. Counsel for the petitioner submit that as per the record the LS seizure was made on 30th September 2023, but the sample was sent a sample was sent for the laboratory chemical examination after the period of 68 days. He further submits that after the dispatch of the material for chemical examination, the same was received by the State Drugs Council, State Drug Control and Research Laboratory on 4th of January 2025, on 7th of December 2023, 13th of December 2023. Counsel for the petitioner submitted there is a delay in sending the materials to the CFSL, for which the petitioner is entitled to get the bail. Counsel for the petitioner further submit that one of the case is at the stage of evidence, and one of the seizure witness has been examined as PW2, and he has not supported the case of the prosecution, and as said, there is no chance of convicting the petitioner, and thus there is no chance for keeping the petitioner in the custody for further police. Learned counsel for the Learned counsel appearing for the state submitted that investigation has been completed, charge sheet has been framed, and the case is at the stage of trial. 2 witnesses have been examined, and the next date is fixed on 11th of June 2025 for examination of the other witness. Police counsel for the state further submitted that the petitioner, though in the custody, but has influenced the witnesses, which is itself shows from the record that the PW2, who is one of the seizure witness, has become hostile. And if at this stage, if the petition is released on bail, there is every chance the other witness will be, and the petition will hamper and tamper with the other evidences. Counsel for the petition submitted that before the present application on the earlier occasion, on the 5 times the petition has filed the present. Before the present filing of the present application, the petitioner has filed another 5 applications on the earlier occasion, and all the applications have been rejected. And in the present application, the petitioner has not made out any new case. And he prays for rejection of the bail application. Heard the learned counsel for the respective parties, peruse the materials on record. This court find that commercial quantity of the narcotics have been seized from the possession of the accused, and the case is at the stage of evidence. 2 witnesses already been examined, and the next date is fixed on 11th of June 2025 for examination of the other witnesses. Thus, CRM NDPS 11 of 2025 is rejected.
I'll the exception note, I'll hand over a copy to the.
Yes. You.
Right now got it, madam.
So appearing for the petitioner, so appearing for the state. No, ASG appearing for is appearing for the state. Learned counsel for the petitioner has filed the affidavit, exception to the report, exception to the affidavit filed by the state, After serving the copy to the learned counsel on learned ASG, let the matter appear on 21st.
My lord, if I may just point out, my lord, kindly makes it DSG
DSG, not ASG, DSG.
and Union of India, my lord.
DSG for Union of India, not the state, huh? Next. Seven, who is appearing?
Lordship, I am appearing for the petition,
Yes,
but
Not Mr. Biswas is appearing, he is moving a matter before court number 4, madam.
what I request Lordship, that after seeing the future of 4, 5, 6 continuously, I wish to try my luck in next circuit, if your Lordship may kindly allow. Because it is on the same footing on the.
you withdraw,
Rule
then you, that this court, that's why this court is not allowing that procedure. Next circuit, try your luck. Bench hunting, this court will not allow.
The Lordship
If you have-
also
if-
protect Mr. Vishwas from.
Pass over.
For the petitioners
Hmm.
have been reeled under section 20B2 and 29 of the NPS Act.
Hmm.
My lord, they have been languishing in custody.
My lord, actually, what happened, I left the city in my chamber. So a long passover may be given so that I can go and bring it.
Okay, if you come, we mention we should do. Yes.
And my lord, they have been languishing in custody for last 138 days, my lord.
What is the case? What is the action?
I have, my lord, 3 full contention, my lord. My lord, my first contention, my lord, pertains to, my lord, potential procedural loopholes with regard to, my lord, section 42(2) of the NDPS Act. My lord, if your lordship kindly have a look on the first information report,
42(2).
42(2), my lord. That is, my lord, the sending of the information, my lord, before conducting the search and seizure. My lord, here from the narratives of this suo motu complaint, it reflects that, my lord, only a mere whimsical formality has been done. My lord, the strict compliance of 42(2) has not been, my lord, done.
Hmm.
My lord, in this regard, my lord, I want to, my lord, rely.
Yes, so how you can say 42(2) from which document?
My lord, page 9, my lord, kindly have a look on
Yes,
the.
page 9.
Yeah, my lord, the first information report.
Yes. Yeah. Yes.
My lord, after clause 5, my lord, the first paragraph start with
Ah.
SI
Yes.
Vasan Murmu.
Yes.
My lord, may I read it out? My lord? Yes. But SI Vasan Murmu, my lord, Kundibadi PS, district such and such, do hereby lodge this complaint against the 6 accused above named accused persons to the effect that on such and such I received information from a reliable source that some person are carrying huge quantity of Raja in a vehicle bearing number such and such from Mikuzukiar site and will proceed Shiliguri for its clandestine disposal stock. The fact was diarized by Kundibadi case number such and such. Accordingly, I informed the matter to the OC Kundibadi case and she also informed the matter to the superior.
Yeah.
My lord, a mere formality has been done.
Hmm.
So far, my lord, the strict compliance of section 42 is concerned, my lord. The information must be sent to the superior.
Hmm.
Until and unless, my lord, it is sent physically or by any electronic modes, my lord, section 42 is not complied with.
Correct.
My lord, in this regard, my lord, I want to rely on the judgment, my lord, Colonel Singh versus State of Haryana, the last paragraph. My lord, internal page 12,
Yes.
paragraph C. My lord, thereafter, my lord, kindly come to page 11 of my lord, bail application. It's the memo of arrest. My lord, another, my lord, procedural lapse.
Hmm.
My lord, by virtue of section, my lord, 52
Hmm.
and my lord, by virtue of article 22
Hmm.
of our constitution, my lord,
Hmm.
the grounds of arrest
Hmm.
must be, my lord,
informed the arrestee. That has not been done.
Yes,
My lord,
very,
so far this memo of arrest is concerned, my lord, nothing has been done with this regard, my lord.
yes,
This is a clear violation of, my lord, constitutional mandate.
yes.
My lord,
Yes, where is, which portion you are relying upon?
my lord,
Paragraph,
in this regard, my lord, I
page
rely
11.
upon Pankaj
I
Bansal.
will come to the judgment, which portion you are relying upon with paragraph 11, page 11.
My lord, paragraph 29.
Page 11 you have referred to, what is for that?
Page 11, my lord, page 12, my lord.
Page 12.
The earlier judgment, Colonel Singh, page 12, last.
No, you have just relied upon your page 11 of the petition, arrest memo.
Lordship. That is the, my lord, memo of arrest.
Yes,
That is the memo of arrest.
yes. Yes, what? Which
My lord,
portion you are relying
In
upon?
this memo of arrest, my lord, there is no statement, no column which with regard to, my lord, that the grounds of arrest has been, my lord, informed to the arrestee. Nothing has been done, my lord. From the bare perusal, it doesn't reflect, my lord.
When he was arrested?
My lord, he was arrested, my lord, on
1st
1st
January
of January 2025.
25.
Yes, my lord.
Have you made an application for the, earlier you have filed an application for bail?
No, my lord, no.
This is the first application?
First application. My lord,
Yes.
My lord, in this regard, my lord, I have, my lord, already handed over. My lord, kindly come to Pankaj Bansal versus Union of India.
Yes,
My lord, paragraph number 29.
yes.
My lord, page 13.
Hmm.
My lord, in this
Yes,
paragraph start with, my lord, in this regard, we may note that Article 22(1) of the Constitution provides inter alia that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. This being the fundamental right guaranteed to the arrested person. The mode of conveying information of the grounds of arrest must necessarily be meaningful so as to serve the intended purpose. Well, that is the operating portion, my lord. It's a constitutional mandate.
yes. That's all.
And my lord, my third contention is, my lord, so far, my lord, the first information report as well as, my lord, the seizure is concerned, my lord, it doesn't attribute to, my lord, conscious possession, which, my lord, lateral culminated into joint possession. My lord, there are 6 persons.
Correct.
This particular petitioner happens to be, my lord, the driver and, my lord, the agent, handyman, my lord. So these persons were carrying, my lord, other 4 persons, the passengers, who were carrying those contraband articles, my lord, which was completely beyond the knowledge of this petitioner.
What is your name?
My lord, my name is, my lord, Nurjamal Mia and Rashidul Haq.
You two. There are two.
I two, my lord. They are
Yes.
the, my lord, the drivers.
Where is the seizure memo?
My lord, the seizure memo.
Lordship, here.
Kindly come to page 12.
Yes. Yes. From whom it was seized?
No, my lord, no
From all.
indication, no particular indication is there.
Where is the signature of your accused persons?
But,
Name
on
and
the
address of
left
the
side,
witnesses from whom seized from the joint
Joint
possession
possession
of
of
6
six
accused
accused
persons
persons.
concealed
Concealed in the back
concealed
seat of
in
the Maruti
backside
van
of the
such and
Maruti
such.
van.
And this is not a commercial vehicle, Lordship.
Yes,
Lordship, I have given this is a list.
yes.
So, Lordship, now when Caesar is there, Lordship,
if
and it's
there
a
is no, my lord, direct evidence.
it's a commercial quantity, seized from joint possession. So,
My lord, appropriately 20 kgs, my lord.
Where is the signature of the persons?
Lordship, Lordship sees the site of the Caesar list. The accused person's name is Lordship Nur Jamal Mia and Rashidul Haq.
Okay. Yes.
FSL report received, but C has not submitted yet.
It's not submitted.
No.
Yes.
FSL report, Lordship,
So, my lord,
is Gaja.
so, my lord, 6 persons were there, my lord. So, my lord, so far this, my lord, the narratives of concern, my lord, it doesn't, my lord, attribute to, my lord, conscious possession. And ultimately, my lord, which culminated into, my lord, joint possession, my lord.
There is no, my lord, direct evidence that those contraband articles, the containers, where, my lord, belongs to, my lord, these particular petitioners.
Hmm.
There are 6 persons almost in the, my lord, vehicle.
Hmm.
And, my lord, the presence of that contraband articles were completely beyond of these petitioners, because those 4 persons were the passengers, my lord.
Hmm. Yes, then that's all. That's all.
So, my lord, when, my lord,
When the report is filed,
Lord, the report was filed on 16 January 2025.
16 January.
It was sent on 7 January, and on 16 January, the report was received.
Yes. Investigation completed?
No, Lord, charge sheet not submitted yet,
Yes.
because 180 statutory is still.
So and so appearing for the petitioner. What is the good name?
Tuman Nam.
No, your name.
Subhashish Misra.
Shubha. What is Subhasis?
Subhashish Misra.
Subhasis Mittal, an advocate appearing for the petitioner. So and so. What's the good name, sir?
Mr. Ganguly.
Mr. Ganguly, an advocate appearing for the state. State or additional PP?
No, I'm just
State.
panel.
State. Police. The petitioner has filed the present application. Present application under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023. Praying for bail in connection with Kundi Bari Police Station case number 2 of 2025, dated 1st of January 2025, under section 20 within bracket small b within bracket II within bracket small c /29 of the NDPS Act 1985, pending before the additional session judge, first court, Sadar, Kuch Bihar. Police. Counsel for the petition submit that the police has arrested the police has initiated the case on 1st of January 2025 and arrested the petitioners hearing on the same day, and since then the petitioners are in correctional home. Counsel for the petition submitted. The police has violated the provisions of section 42 within bracket 2 of the NDPS Act and submitted that and has brought to the notice of this court to the complaint wherein it is categorically mentioned that on receipt of the alleged information, the sub-inspector of police Kuch Bihar has not complied with the provisions of section 42 within bracket 2 of the NDPS Act, but has alleged to have seized the narcotics. Counsel for the petition submit that counsel for the petition in support of his submission has relied upon the judgment in the case of Karnail Singh versus the state of Haryana, reported in 2009 volume 8 SCC 539, and submitted that a requirement of section 42 within bracket 1 and 42 within bracket 2 with regard to the information in writing and sending the copy there to the superior officer is required to be followed, but in the present case the police authority failed to follow the said procedure. Counsel for the petition further submits that though the petitioners have been arrested, but in the arrest memo there is no reason has been assigned as to why the petitioners have been arrested. And as such, if the police authorities after the in the arrest memo reason has not been assigned, which is the same violates the provision of Article 22 within bracket 1 of the article of the Constitution of India. In support of his submission, he has relied upon the judgment in the case of Pankaj Bansal versus Union of India, reported in 2023 SCC online SC 1244, and submits that no person shall be detained in custody without being informed as to why he has been arrested. Police to. Counsel for the petitioner further submits that as per the alleged seizure list, it is mentioned that the alleged narcotics have been seized from the joint possession of the 6 persons. But in the seizure list, there is no name appearing of name of the petitioners are not appearing in the seizure list. And as such, it cannot be said that the 6 persons, out of the 6 persons, the petitioners are also the persons from whom the alleged seizure was made. Per contra, an advocate appearing for the state submits that when the information has been received accordingly is received by the sub-inspector of police, accordingly for compliance of the provisions of 42(1) and 42(2) of the NDPS Act, the same was duly informed to the superior officer, and in presence of the superior officer, the alleged seizure was made in the joint possession of all 6 persons who are involved in the matter. He further submit that in the seizure memo, it is categorically mentioned that the alleged alamat have been seized, alleged narcotics have been seized from the joint possession of the accused persons, though the name has not been mentioned in the seizure list, but the signature appears but the accused person, the petitioners have put their signature in the seizure memo, which privacy prove that the seizure was made in their presence. So counsel for the state further submits that as regard the arrest memo, it is categorically informed to the wife, to the relative of the petitioner, and the petitioner had the knowledge that the narcotics have been seized from the possession of the petitioner. Thus, it cannot be said that the same was not informed to the petitioner at the time of arrest of the petitioner. Had the learned counsel for the respective parties peruse the materials on report and the judgment denied by the petitioner. As per the case of the prosecution, on receipt of the information by the sub-inspector of police, the same was informed to the senior officer, and in compliance with the provisions of section 42, the seizure was made. Police. This court has perused the seizure list in serial number 3. It is mentioned from whom seized, and in the said column it is mentioned that from the joint possession of 6 accused persons. 6 accused persons, but it is not mentioned, but the name of the persons has not been mentioned in the said column. As and the prosecution has relied upon but the signature on 2 of the accused persons have signed, but other persons have put their LTI. Full stop. Where is the notice issued to the accused persons under 52?
Hold on.
Date and time दिया है देखो. Date and time दिया. Date and time. The counsel for the state submit that the seizure was made only after service of notice under section 50. This court has gone through this notice issued under section 50, but the notice does not reflects on which time the notice was issued to the petitioners. Full stop. This court also considered the arrest memo. In the arrest memo, there is no mentioning with regard to And there is no mentioning with regard to information to, there is no averments that, the petitioners have been informed with regard to their arrest and reason for arrest. Police. Considering the above, this court find that the petitioners have come out from the provisions of section, has make out the case to come out from the provisions of section 37 of the NDPS Act. Accordingly, the petitioners are entitled, according the petitioner may find bail of rupees 10,000, rupees 5,000 each. One surety must be local. Full stop. If on bail, they shall appear before the investigating officer as and when required by the investigating officer, and shall also appear before the trial court on each and every date of hearing. And they shall not leave the concerned jurisdiction of the police station without the leave of the trial court. CRM number so disabled. Yes. Why?
Point of round of arrest. This will be adjudicated on Wednesday and we have the same ground. So if the point is made clear, then we can move on with our.
As per the prayer made by the petitioner. Let the matter appear on 22nd May. Next. Yes.
Lordship, this is the second application. First one was not placed on 13th February 2025. It is in page 8, Lordship.
Yes.
Now, Lordship, this petitioner was shown arrested in connection with this case. He was arrested in another case, in where also nothing recovered from him. Basing upon proactive statement, he was arrested in that case. And this is page 9, that is the shown arrest prayer which was made on 5/11/2024. Page 9 of my petition.
Page 9.
Lordship.
Record is put up, supplementary record along with the written remand census and so on authorization letter submitted by your collecting officer, one intimation. Your census and supplied along with the case diary submitted for census and so.
Shown arrest prayer.
Given a jail authority, produced the accused Sanjay Patel, considering your census has appeared along with the case diary and submitted a prayer to the PP in charge for issuing shown arrest.
Though this is
The accused Sanjay Patel census and so on the ground stated therein, presently in custody in Jalpaiguri correctional home. I think the IO may be considered in the first physical appearance of production report within custody in connection with the case as reported according that the production warrant be issued against the Sanjay Patel. Yes, then
on page 11, order dated 12/11/2024. Where he was booked in this case.
you may direct not to make any type of given the police custody.
He was in no, he was in JC in another case.
So you are sent to police custody, remanded to allow the one submission census appeared on the basis of production warrant. Sanjay Patel was produced.
Sure.
Correct. Then
I was booked in the case.
Then now the record is taken off census census producing case diary appeared for 14 days police custody for the in connection with case.
Then I was taken in PC.
That's why I'm telling you. He was
Lordship.
taken to the police remand.
Lordship.
Police remand allowed for 12 days.
12 days. Now, Lordship, page 13. The person from whose statement my name transpired.
Yes. 13 is the FIR.
31. Lordship, I'm
Page?
sorry. Page 31.
Yes. 483.
The
Kushal
person-
Singh. Kushal Singh.
Huh. He has mentioned my name, and basing upon his statement, I was booked in this case. That person has been enlarged on bail.
Where from you, he has stated your name.
Lordship, because Lordship will find this shown as page 9,
Huh?
where I was,
Correct.
so the extract of city was produced, where the name of my name transferred from me.
Hmm.
Now, Lordship, can you see page 20, see the list,
20.
20.
Hmm.
Not seized from my possession.
From whom sees Sumit Mishra?
Other two. I can say.
Push call. These are the two persons.
Lordship, page 14 is the letter of complaint. I am not even named in the same.
14.
14. Now, Sumit Mishra and Kaushal call. They made the Kaushal Singh.
Yes.
Kaushal is a supplier, and Sanjay Kumar Patel, that is the petitioner, was the owner of the vehicle, commercial truck.
Who?
Now, Lordship,
Who?
the petitioner
Hmm.
is the owner of the vehicle, commercial truck. Now, in this similar point, Lordship, the apex code has dealt with that in a case where I have been shown arrested, where I have a previous case also, where nothing, admittedly nothing recovered from me, what happens, Lordship? May I read along, Lordship?
Yes.
Para 2. Learned counsel for the respondent state vehemently opposes the petition. He submits that since the petitioner is also involved in a previous case, in view of the bar under 37 NDPS Act, he is not entitled to bail. We have perused the material on record 4. Insofar as the previous case is concerned, there is no recovery of contraband material from the petitioner. In our case also same. The allegation is that the recovery is of money which was, and in our case there is no money even. 5. In the present case also, the recovery of the contraband material is from the brother of the petitioner, here or other accused persons. The allegation is that the vehicle which was used for the crime belonged to the petitioner. In our case also, the vehicle. And that vehicle was used with the knowledge that the same is used for transfer of the contraband materials. Here also the allegation is the same. Taking into consideration of the fact, neither present case nor in the earlier case there is recovery directly from the petitioner, we are inclined to allow the bail. Now, this is the order sheet of the previous case. Can you see, His Lordship, in that case also nothing recovered from me and I am in bail.
Yes.
So, Lordship, nothing recovered. Do I do statement?
Yes.
Something.
Lordship, commercial quantity,
Is there any recovery from this petitioner?
no Lordship. Statement of the co-accused, his name transfer and he is a drug dealer Lordship and he has antecedent Lordship.
Huh?
Charge sheet file with report. Charge sheet file with chemical report, he has antecedent Lordship. In
Antecedent?
previous case, previous
That's
case, he was
previous
arrested.
case. That's all.
Oh, adding section is there Lordship, forgery section. Forgery section.
So offering for the petitioner. What's the good name? Subhash?
Ganguly.
Subhash Ganguly. Saurav Ganguly, advocate appearing for the petitioner. What is your good name?
Mr. Chottu Rai,
You are appearing for state?
State Lord.
Or TP?
State Lordship.
So appearing for the state. The petitioner has filed the present application under section 483 of Bharatiya Nagrik Suraksha Sanhita 2023 in connection with Kotwali within bracket Kuch Bihar police station case number 731 of 2024 dated 16 July 2024 under section 21 within bracket small c /25/29 of the NDPS Act 1985 pending before the learned additional session judge first court within bracket NDPS Act at Kuch Bihar. Counsel for the petitioner submitted that when the instant case was registered by the police, the petitioner was in correctional home in connection with another case. Subsequently, on the prayer made by the investigating officer, the petitioner has been shown arrest in the present case. And as per the prayer made by the investigating officer, the petitioner was taken into police remand, but nothing was seized from the possession of the petitioner. Counsel for the petitioner submitted. In the earlier case also, in which the petitioner was in correctional home, nothing was seized, and he has relied upon the bail order passed in CRM NDPS 152 of 2025, dated 25th April 2025, wherein this petitioner was granted bail in connection with the another case. And this court has recorded that nothing was recovered from his possession. Full stop. Counsel for the petitioner submitted. This petition has been entangled in the instant case only on the statement made by the co-accused. Police per control and advocate, no, police counsel for the petitioner also relied upon the judgment and the order passed by the Honorable Supreme Court in the case of Carul, Khairul, Carul SK versus State of West Bengal, dated 19th January 2025 and 2024, in special leave appeal within bracket criminal number 13282 of 2023, wherein the Honorable Supreme Court has granted bail to the petitioner of the said case, holding that the said petitioner was the petitioner of the said case was also in custody prior to shown arrest in the said case, and nothing was seized from the said accused from the earlier case, and the case of Carol SK similar to the case of the present petition. Police. Per counsel and advocate appearing for the state submit that the as per the statement made by the co-accused, the petitioner has been included in the present case, and accordingly, and the investigating officer made an application before the London magistrate to show this petitioner in the present case as accused, and he has taken to the police custody. During the police custody, the investigating officer has found a case against the petitioner, and on completion of the investigation, charge sheet has been filed. Counsel for the state submitted the petitioner is involved in the matter, and as such, if at this stage the petitioner is released on bail, the petitioner will hamper and tamper with the evidence. Had the learned counsel for the respective parties peruse the materials on record. This could find that when the present case was initiated, the petitioner was in correctional room in connection with the others. Admittedly, nothing was seized from the possession of the present petitioner in the present case. Police. Only on the basis of the statement of the co-accused, the petitioner has been entangled in the present case. Even the police has taken the petitioner on police remand, but nothing was recovered. Police. Considering the above and the judgment passed by the Honorable Supreme Court, this court find that the petitioner has made out a prima facie case to come out from the section 37 of the NDPS Act. Accordingly, petitioner may find bail of rupees 10,000 with two sureties. One must be local, with the satisfaction of the learned court of additional sessions judge, first court NDPS at Kuch Bihar. If on bail, he shall appear before the learned trial court on each and every date of hearing, and shall not hamper and tamper with the evidence.
Lordship, my objection, Lordship, online, Lordship.
Are you recorded?
Lordship.
CRM numbers disposed of. Are you recorded your submission?
Yes, Lord.
Which one? Which matter?
Item 7.
Give,
Item number 7.
call, who is the petitioner? Petitioner's not here.
Mr. Shortcut, he was there, he just spoke to me.
He's not here. He will come then mention. Call the matter.
For short passover, my land.
What? You are only for short over and adjournment since beginning. I am. Huh? Who is your senior?
Subhashish Mishra.
Subhash, he was here just.
He was just in court number 4.
Pass over. Next.
Item number 12.
Yes. Lordship, kindly take the
Plastic
page-
bag containing 3 cartoons.
Not
100
from me,
total.
Not from me.
Not from you.
Page 16. see the
What?
list.
That's why I'm saying.
Page
What is
16.
your name?
My name is Lordship, Shahidul Ali Khan.
Saidul Ali Khan.
Page 16, Lordship, see the list.
Rakibul Islam.
Lordship,
Rakibul Islam.
Lordship. Now,
Then-
Lordship, kindly see page 10, when I was arrested and forwarding report.
When you was arrested.
Lordship, I was arrested subsequently. The case was I was arrested, produced before court for the first time on 21st January 2025. The case was registered on, Lordship, the FR is 9/9/2024.
9/9/2024.
Court. I was produced before the court, forwarded before the court on 21st January 2025. And
20
this is, Lordship, page
21st
30
January.
January 2025.
Where is that?
Lordship, page 13. Lordship, the date below the signature SI Ganesh Burman.
This is forwarding.
Forwarding.
Yes.
Now, Lordship, the second paragraph,
Which page?
page 13.
Yes. During investigation, I
Rookie
indicated
statement 67 NDPS Act.
when he confessed that another involved person, namely Sakibul.
Lordship, that is the petitioner.
Yes.
Now, the
Correct.
next paragraph, Lordship.
Yes.
On 16/1/2025, as per source information, I held raid at PS Bongaigaon, Assam and arrested accused. What is Lordship?
Saidul, yes.
So this is it. Now charge sheet has been submitted. Now kindly Lordship sees, this is the most peculiar thing. Lordship, page 19. 9th line from bottom. Ninth line from bottom. On 26/9/24, I had been to Assam to held raid. What is Lordship? Raid at the house of Shahidul Ali Khan. Lastly, on 16/2/2025, it would be January because I was produced on January and he say I was arrested on February. This is
So 3 months he was in Assam.
Assam.
The investigating officer.
Lordship,
Went to Assam.
Lordship, my learned friend has argued on behalf of this accused petitioner, that is Shahidul Ali Khan. Actually, he is emboldened on the strength of the order passed in the by your lordship while dealing in a bail petition of Rakibul. Actually, the Rakibul was enlarged on a bail after relying on the judgment of the Honorable Supreme Court, that is Jigar alias Jimmy. And in that, my learned friend also at that time argued that a petition was filed for extension on 25th February without serving notice.
That is different thing.
I'm coming to that part just 1 minute. But actually, that order was not right. That case was not rightly placed before your lordship because the case initiated on 9/9/2024 and the charge sheet has been submitted on 6th March 2025. That is in on 178 days. So the question of extension does not arise. After 180 days, the question of extension arises. So Rakibul was enlarged on bail on the basis of Jigar alias Jimmy, showing that the privilege of objecting the extension application was not given to the accused, so the accused was enlarged. But in the Rakibul of the principal accused of this case, but the charge sheet has been submitted on 178 days. So question of the taking the privilege of that point Does not arise, Lordship.
No, he is not taking that point.
No, I'm submitting
He is
because,
taking this point
Oh,
whether
it is-
anything was seized from the possession of
yes,
charge.
Lordship, while passing the order, Lordship, the charge sheet was because the investigating agency also got astonished. The charge sheet passed on, submitted on 178 days, and the accused petitioner got the privilege of not objecting the extension, because the charge sheet is within the statutory period. So question of default bail does not arise.
That was not brought to the notice, mind you.
That was not brought to your Lordship's notice. That is the important.
That's why since beginning I am
And-
telling
and
you,
this
you all
petition-
persons are not bringing all the documents on record while
Lordship.
filing application.
May,
What?
as because this.
Let the not.
No, as because this point has been raised, I am pointing out, it was a typed petition by the prosecution signed by the IO, para 11.
Correct.
Lordship, date, can you see the date?
That's
The
what
charge sheet was
telling.
submitted subsequently.
No, Lordship, no. No, Lordship, subsequent charge sheet was submitted on 6th March
On
2025. No, 6th March.
Lordship, can you see the order of the.
No, not
March?
today is the 169th day and 180 days, that is a statutory period, will be completed on
See,
6th.
charge sheet was submitted on 7.
Court now has passed, court has not on that. This court has considered because that application, the put up was made without giving an opportunity.
That was the difference.
Raising this point in this case, there is nothing.
No, this is same case, so I'm
Okay,
raising the point.
So what?
And regarding this accused petitioner, your Lordship, he was on the truck. He was in the truck and he fled away from the spot. But obviously, when he fled away, so the question of seizing the contraband from his possession does not arise. And obviously, his name appeared from the statement of the co-accused. But the
But in the FIR, there is no name. In the FIR, name of the accused.
no, he is not
No,
named in the
so-
FIR.
If you are telling that, so if your case is believed, he was in vehicle and he fled away. So IO, when he submitted the complaint, he could have mentioned that there are two persons, one is fled away and one has been arrested. That is not the case. They have
Lordship, just a second.
There is no such report.
Yeah, no
You
such
have gone
mention.
through.
No such mention. That is
So appearing for the petitioner.
cognizance taken, submitted on 6th March.
And what's the good name?
Moika Chatterjee.
Subject Chatterjee, non-advocate appearing for the state. The petitioner has filed the present application under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for bail in connection with Jalpaiguri NDPS case, in connection Kotwali within bracket Jalpaiguri police station case number 608 of 2024, dated 9/9/2024, for the offence under section 21 within bracket C/25/29 of the NDPS Act 1985, pending before the London Court of Additional Session Judge First Court within bracket NDPS at Jalpaiguri. Counsel for the petition submit that the police has registered the case on 9/9/2024. And in the FIR, there is no name with regard to the petition. The police has registered a said FIR on the basis of the seizure memo, and nothing was seized from the present petitioner. Nothing was seized from the present petitioner. The counsel for the petition submitted that it is a specific case of the petitioner, and it is a specific case of the prosecution that on the basis of a statement made by the co-accused, the present petitioner was arrested. The present petitioner was arrested. Counsel for the petitioner brought to the notice of the seizure list, wherein it reveals that the seizure was made from the co-accused Rabiqul Islam and not from the present petitioner. The learned counsel for the petitioner also brought to the notice of this court to the charge sheet, wherein it is categorically mentioned that the investigating officer had been to the Assam and the petitioner was arrested only on 6th of January 2025. That is much after the seizure. You submitted as nothing was seized from the possession of the petitioner, and the petitioner has been arrested only on the basis of the statement made by the co-accused person, and thus the petitioner is entitled to get bail. Per content, an advocate appearing for the petitioner submit that, and for the state submit that. that the petitioner has been fled away from the place of occurrence and subsequently he was arrested, and as such in the seizure list his name was not included. Police counsel for the petitioner state submit that when the investigating officer came to know about the identification of the petitioner, the investigating officer arrested the petitioner and produced before the learned court, and counsel for the petitioner submit that, and counsel for the state submit that investigation has been completed. Prima facie case has been made out against the petitioner, and as such.
Lordship, one indulgence, the charge sheet was filed within 180 days, one line just.
Counsel for the state submit that investigation has been completed and charge sheet has been filed within the prescribed period of 180 days, and as such, the petitioner is not entitled to get any bail. Heard the learned counsel for the respective parties peruse the materials on record. Admitted, the petition is not the FIR named accused. It is also admitted that nothing has been seized from the petitioner. It is also admitted that the petitioner has been arrested on, has been entangled in the present case on the statement made by the co-accused. The case made out by the learned advocate for the state that the petitioner has been fled away from the place of occurrence is not appearing in the FIR or in any of the report to say that the petitioner was present at the place of occurrence. Considering about this, then the petitioner has made out a prima facie case to come out from the provisions of section 37 of NDPS Act. Accordingly, petitioner may find bail of rupees 10,000 with two surety of rupees 5,000 each. One surety must be local with the satisfaction of the learned court of Learned Court of Additional Session Judge, First Court, NDPS at Jalpaiguri. If on bail, the petitioner shall appear before the trial court on each and every date of hearing and shall not hamper and tamper with the evidence.
Shall not leave the jurisdiction of this court.
And shall not leave the jurisdiction of the concerned police station without the leave of the trial court. CRM.
Much obliged. Much.
Next. Yes. Who is appearing? 65?
I'm for the state, my lord.
Who is for the petitioner?
Mr. Anirban Banerjee. Yes,
None appears on behalf of the petitioner. Learned PP is present. None moved. No accommodation is sought for. Accordingly, CRAN number 1 of 2025 filed in CRR number 75 2025 is dismissed for default.
Get full, my lord.
Yes, you are appearing. You are. How many petitions are there?
Then
So how you are have been authorized? What is your age? Yes. So petition number 1 is the father and 2 is the mother. Yes, what is the case? Bolo. Just a minute. Please keep silent. Please keep silent. Yes.
কথাটা বাইরে হচ্ছে বেশি প্যাসেজে দরজাটা খুললে ভিতরে আসছে
Before my non-appearance.
CRAN.
2025.
When the case was dismissed.
23rd.
Where is the order? Which page? You're not enclosed the page order of dismissal. Where is the order of dismissal, madam?
Annex the order, my lord.
No, without that, how can? When it was dismissed?
When it was,
Till 2000
so without the order, how the can?
22nd.
22nd April,
my lord.
23rd of 2025. No, none
No.
appears for the private respondent. Affidavit service filed with,
22nd, your order, page number 9.
what is the CRR number? 154. Okay, this is a WP number.
No, this is CRAN 2, my lord. CRAN 2, page number 9.
Page number 9. That is the WPA.
That is a WPM.
My lord, that is supporting document, my lord.
That's why there's a WPA.
Did not annex the order, my lord.
So how the CRAN has been accepted?
My lord, there,
You are having the copy. You are having the copy.
not possible. He has served me a copy, my lord. This is the copy of the CRAN. It's not there, it's not the writ
No.
petition.
I'm bringing the order, my lord.
It's not the fact. Thing is the department how has accepted it. That is it.
Passo.
Item number 65 has been reviewed for people and extremely sorry, Lordship. I was in court number.
Somebody has to appear.
Extremely sorry.
जो डिसमिस किया ना उसको करो ना पास हुआ करो yes who is appearing for the petition yeah item number 65 66 67 yes
Lordship, I'm for the state, Lordship. And Lordship, I'm being led by Mr. Aditi Shankar Chakraborty. Lordship, on the last occasion, Lordship, kindly pardon me, Lordship, I'm appearing virtually, Lordship, because of my personal difficulties, Lordship.
appearing for yeah you are appearing for
67.
for the petitioner and you are appearing for
For the state, Lordship.
For the-
Case diary and the Lordship, the last 164 have already been translated, Lordship. It is there in the court only,
there
Lordship.
is a translated copy
Translated copy, Lordship, it is there in the court, Lordship, my translated copy.
This is not the issue, this is not the issue of translated copy.
Ah.
Perhaps, Nine, 69.
67 68
Yes.
Yes.
68.
yes
This is 67. Both the-
67 what is your prayer
There is quashing of 498 proceeding.
ah
And 68 also quashing of 498 proceeding.
Ah.
498.
2498 proceeding has been initiated
Parties are common lordship can be taken up first 68 because it is prior in time.
68 the prior case yes 111 give the other one oh dada 68 though yes what is the case where is the case
The case is this,
so initially you filed the after the marriage there was a dispute how many children One child was born.
Custody battle was there one.
just a minute one child was born there was a dispute
Yes.
then you filed a 13B application what has happened to the 13B
13B application was still pending, still in.
It's still pending
Pending.
why when the 13B was filed
Filing of joint compromise petition, the lady could not come up for deposition for further disposal.
no
This is one plank of development.
Hmm.
Subsequent thereto, there is that situation turn into a different situation. Why? Because there is a custodial issue, custody of the child battle was going on, and it was.
who filed the custodial child is with the wife
Yes,
and you have filed an application 26
yes, 26.
ah
It was attempted to decided by the Ranget trial court,
Hmm.
and what happened?
what is the prayer in the 26 pray for the custody of the minor
Minor.
then what has happened
I paid for custody of the minor, I
Ah.
being the husband,
Ah.
paid for, which was not considered.
Ah.
Subsequently, the matter abruptly came up before this honorable high court in
Mediation.
jurisdiction at the behest of the wife. That habeas corpus application was disposed of by this honorable court.
directing the petition, directing the concerned child welfare committee to hand over the custody of the child from to the wife. And pursuant to the direction, the custody of the child was handed over to the wife.
Why, how the child came to in your custody?
It was taken by the police, pursuant to a GD entry lodged by me, and subsequently it was taken to the institutional care. Subsequently.
No. Initially, the child was with the mother.
Yes,
Correct.
yes,
And you filed an application 26.
yes.
26th application was rejected.
Yes.
Then how the child came to in your custody?
In a police
Acha,
case,
you made a police case,
police
then
case.
police has handed over to you.
handed over.
Then the child was.
Not me, not me. The child was brought to the Juvenile Justice Board, Child Welfare Committee. The Child Welfare Committee was in custody of the child. Subsequently, habeas corpus taken up. They are pursuant to the direction of the habeas corpus court. The child was handed over to the mother. Now, this is another plank of litigation.
No, so once the child was brought to the CVC, then what has happened?
Child Welfare Committee handed over the custody of the child to the mother, pursuant to the direction of the Honorable High Court.
So where was the child? And child was with the mother only.
Is currently with the mother.
Correct.
Now, the subsequent this after long prolonged litigation lordship, subsequently this FIR was registered on 16th of July. 18.
No, 27 July 2021. This is the first FIR, 27 July 2021. This is 27 July 2021. This is the first FIR.
Yes,
Correct.
Yes.
And then the investigation completed.
Investigation
Charge sheet filed.
I cooperated. Charge sheet filed. Subsequently, charge sheet. So far, the findings of the charge sheet it appears there is a mechanical charge sheet, no material, no seizure, nothing that sort of. That's why I taken out this revision application. It was initially stay order was passed. And subsequent thereafter, after 2 months thereafter, the second 498 proceeding was lodged by the wife against the petitioner.
In which PS?
Same PS.
Same PS.
Same PS. Same PS. She is in habit to.
Then what has happened? Sir, in that case also you have been granted bail.
Fine, yes.
And charge sheet is filed.
Charge sheet filed. I prefer divisional application stay allowed, and both are before your lordship. Now this is another thing. Second aspect is third aspect is that there since the honorable division bench has taken up the issue of matrimonial issue and all these things, and the honorable division bench justice led by Justice Somen Sen.
Appointed the mediator.
Yes.
Went to the mediator filed the final report.
Yes.
She has not turned up.
Yes.
Then
it
yes.
was not successful.
Correct.
Initially in Calcutta.
Correct.
Subsequently, the mediator the mediation was said.
Correct. The mediation failed. She has not appeared. Then what is
the mediation was failed. That was also failed.
Correct.
Now this is the entire situation. Now this is the contested application which I am praying for crossing of the both the.
What are the grounds? Show me. What are the ground?
Yes. Kindly see that at page.
Where is the wife now?
Wife is residing separately.
Have you filed another divorce application or the 13B is going on?
13 is going on.
13B is still pending.
Yes.
You have not filed any further application. Yes.
Recently, in the year of 2025 and 2024, she lodged third and fourth 498. That are still pending investigation. That has not been charged yet. I also complied with all the cooperated with the investigation. So this is I have been harassing and all.
Yes.
She is residing for last couple of years separately, but this 498 proceeding is going on.
Yes. Where is FIR?
FIR is at page 28 of my application.
Yes. So how the other three complaints, the FIR is chalked out after these two FIRs?
No, I didn't.
There's no FIR.
No.
No, in that other you are telling that after these two FIRs, another FIR, other two FIRs have been chalked, just you submitted to them now. Another FIR is chalked out or not?
FIR has been registered.
Where?
I have not got on record of it.
Which PS?
Same PS.
What?
Siliguri only.
What is doing your police?
I'm telling informally, Lordship, the police has said that they are also very much worried because the lady is so cantankerous that he come to the police station and lodged the complaint and made request before the police station. They routinely registered FIR.
Which one? Other cases also.
First case, my lord.
These are the two cases. Now he's telling the other two cases have been registered.
This is the first case, my lord.
This is the first case on 27/7/2021. That's the 27/7/21. Correct. And second is.
Second is 7/10/2021.
Yes, please. No, second is of, yes, 7/10/21. 21. Correct.
Yes.
So other than these two other. Huh? Yes, Pradhan Nagar case, and this is of Siliguri Women Police Station.
Second is Pradhan.
Pradhan Nagar case. And where is the other two?
Other two, Lordship, I
You have a number?
But actually, but I am holding the case study of my lord, first case, my lord. 27/7/2021.
And Mr.
Case study is required.
Mr. Luxam is appearing for the other. I think just he stated that he is appearing for the state.
No, my lord.
No, Lordship, I was, Lordship, kindly pardon me, Lordship, I was confused with item number 69, Lordship.
Okay. Okay. So other is also pending. So you take steps, bring all the things in a case.
Completed, my lord, and chassis will be submitted.
Correct. See how the police every day registered an FIR. Once the case has been registered, a charge sheet has been filed. So every day they can, whether the lady will come to the police station and there is no work of the police in the police station.
should I take up all this FIR subsequently registered?
Not only that, I have also my lord, instructions from the.
Correct.
concerned police.
Which police station the FIR has been
Pradhan Nagar.
chucked out? You don't know?
As far petition is concerned,
No,
my lord,
this
what
is one is the women police station Siliguri and another is the Pradhan Nagar.
Yes.
What about the other two? You have
Pradhan Nagar.
both.
I have only one Pradhan Nagar case and one.
Subsequently.
So and so appearing for the. What is the good name? What is the good name?
Shah.
Alok Saha. Arnab
Arnab.
Saha, then an advocate appearing for the petitioner.
But Aditya Shankar Chakraborty, very proceed.
Aditya Shankar Chakraborty, an advocate appearing for the state. Full stop. The petitioner has filed the present two revisional application being CRR number 110 of 2023 and CRR number 111 of 2023, challenging two FIRs initiated by challenging the two criminal proceedings initiated by the wife under section 490, wife of the petitioner under section 498A of the IPC, that is one before the Siliguri Women Station and another is before the police station dated 27/7/2021 and another before the Pradhan Nagar police station dated 7/10/2021. Full stop. Counsel for the petition further submitted during the pendency of these two cases, the wife of the petitioner has again made a complaint, again made several complaints to the Pradhan Nagar police station, and he came to know that the Pradhan Nagar police station has initiated another two FIRs.
Yes, may I cite the difference?
Yes.
Pradhan Nagar police station case number 764 of
Being
2024.
Pradhan Nagar police case number
764 of
अरे आगे
2024.
लिखो being प्रधान नगर अरे नीचे अभी लिखो being अभी कहाँ लिखा ना being प्रधान नगर police case number
764 of 2024.
764 of 2024
Dated 26th of November 2024.
dated 30
26th of
26 November
2024.
2024 and
another is Pradhan Nagar police station case number 529 of 2024.
2024 dated
18th of October and 18th of August 2024.
18th August 2024. Full stop. Considering the police counsel for the petition submitted, he may be granted leave to take appropriate steps with regard to the other two FIRs. In view of the above, the case is adjourned. The petition is given liberty to take appropriate steps to the subsequent FIR initiated by the petitioner, initiated by the wife of the petitioner.
Relevant city may be brought on record.
You take a step, then I will call. By this circuit? No, next circuit. Let the matter appear before the next circuit bench. Next circuit. This is 68, 69 both, huh? Yeah, 69.
Yes, 69, Lordship.
Yes.
If the petitioner is facing charges under POCSO Act,
Hmm.
the petition
ये बंद कर दो.
submitted.
Online बंद करो.
Lordship, I'm here.
Yes.
So the charge sheet has been submitted, but subsequent thereafter, thereafter the petitioner has taken out an application for discharge of the application, disclosing the groundless.
66.
Item number 66.
Yes, where is the order?
My lordship, on that day, I have medical emergency which
No, no, madam, this is not the dismiss for default. This has been disposed of on merit.
Yes, my lordship,
So,
that's why I want
The
to
revisional
recall.
application disposed of with the direction that the petitioner shall be at liberty to agitate the issues in the present revision application before the trial court.
My lordship, I want to recall that order, my lordship.
Can't, in the criminal, it can't.
My
In the
lord-
criminal case, it can't, the order cannot be recalled in the revisional jurisdiction.
My lordship, this matter has many merit. I am
Correct, but the court has passed an order giving you liberty to raise all the objection before the trial court. If the trial court will not hear you or pass any order against you, then you can file another application. But this court cannot revive this order in the criminal jurisdiction. Which court? Matter is pending before which court?
lordship, assistant district and session judges court at Alipurduar.
Additional district judge, Alipur. Go on where you are residing.
My lordship,
So
Alipurduar.
go to the court. When is the next date fixed? You are the accused person in that matter.
Yes, my lordship.
You are the accused.
Yes, my lordship.
What application you have filed here for
My lordship,
discharge?
charge has been framed, my lordship.
Charge is framed. And what application you are quashing? Why you not appeared?
My lordship, for medical emergency, my lordship, I attached the prescription and the day before only and read order has been passed
That's
by
correct,
this court.
but this court cannot revive the CRAN by way of CRAN. This order cannot be recalled, madam. This is not dismissed.
My
This is
lordship-
a disposed of matter.
If not anyway, my lordship, one day only, that day only.
Correct, but the order is passed. Order is uploaded. Other party had appeared. You go before the
My lordship, charge has been framed. That court will not entertain and this evidence will take many.
what is the case against you?
My lordship, this is a false case, my lordship.
What is the case? What is the
My
section?
lordship, 307.
Where is the charge sheet? 447, 323, 325, 326, 307, 550, 350. The complaint case? It's a complaint case. Police case.
My lordship, page number of the main file.
28. Where is the charge sheet? 28 is not there.
Civil in nature. First, I have.
Correct, but this court cannot pass any order, madam. Sorry. Already the coordinate court has passed an order. So this court cannot interfere in that order. And that too in the criminal division. If it is civil, you can find a review, but the criminal division, how? So and so appearing for the petitioner, so and so appearing for the state. And the petition is appearing in petitioner number 3 is appearing in person. Learned PP is present. The petitioner has filed the present application for recalling of the order dated 23rd of April 2025, wherein this court, in the absence of the petitioner, has disposed of the revisional application with the liberty to the petitioner to raise all issues raised in the present application, agitate all issues raised in the present divisional application before the trial court. Police. Considering the above, this court find that the the present application being CRAN 2 of 2025 is not maintainable. Accordingly, the same is dismissed. Sorry. Can't do in the criminal jurisdiction, it cannot.
Number 65 was.
वो तो बोल दिया ना, not today. Yes, call them.
Item number 67 and 68, also I missed one, respect to register your, before your lordship. Regarding Pradhan Nagar police station, both the 498 proceeding lordship. Two subsequent proceeding was assigned before this court, and this court was pleased to stay the both the proceeding. All the CRR be put together. Number CRR number 492 and 494.
Already there?
Yes, already there, and they are.
So where is that CRR?
CRR is 494 and it is.
एक काम करो, you have taken that.
And
67, 68.
67 and 68.
What is the FIR number?
CRR number.
CRR number? उसमें ना
492.
उसमें लेकिन उसको डिक्टेशन दिया 67, 68 ना उसमें लिखो counsel for the petition submit that another two revisional application being CRR number
492 of 2024.
490
492.
92 of 2024 and
494 of 2024.
494 of 2022 are also pending before this court. Let all four revisional application, that is CRR 110 of 2023, CRR 111 of 2023, CRR 4 जो है ना क्या नंबर वो 492 of 2024 and 494 of 2024 be placed before this court tomorrow.
On 22nd.
On 20. Last day I will not take any.
22nd.
Sorry.
22.
Then next.
22. 21.
21.
21.
Next. 69. 70.
My lord, I am for the petition in item number 70, lordship.
Yes. What is the case?
Maintenance order.
Maintenance order.
Lordship.
You are appearing for wife.
I am for the wife.
You are for the petitioner.
Lordship.
Yes, where is the order? Of
This is
the
certified
magistrate?
copy of the, certified
Under
copy of the order.
125.
Lordship.
Yes.
Under section 125.
125, lordship.
What you are doing?
Lordship, Surgeon, lordship, I have a private practice, lordship, but
You are a dental surgeon. One wife?
she is a government employee, lordship.
She is a government employee. What she is doing?
She is at present working in a PHC, lordship, and she is earning more than me, lordship. At present, I am not in a position to run my chamber because some frivolous cases
Okay,
were.
where is the order? Where is the order?
Lordship, certified copy of the order has already been annexed, lordship.
Order dated 11/11.
11th November
2022.
Lordship.
Interim for 4,000.
Yes, lordship, I earn only 15,000
You are a
lordship.
doctor.
But I am not in a position to run my chamber at present, lordship.
Beggar is also liable to maintain the wife, sir.
Lordship, but kindly see the statute, lordship. I am not denying my right, lordship. And
Where is your affidavit of asset? Have you declared the affidavit of assets?
That stage has not yet come.
Not yet come.
Not.
You have declared.
No.
In the application, you are not declared.
kindly
No,
direct
that
them to
is-
file her salary slip, lordship.
You are not declared.
Lord, that
So
is.
let the for the time being you pay. This is the interim maintenance. I am not interfering with the order, but the London magistrate can.
But
pass-
Lordship, one thing,
The
Lordship,
challenge is prima facie laughable, my lord. They have challenged an order of 4,000.
but at
That's
pre-
something.
at present, Lordship, I am earning only 15,000, Lordship, and kindly come to one thing, Lordship, kindly come to section 125,
Which
Lordship,
clause?
of Code of Criminal Procedure, Lordship.
Which clause?
I am showing that clause to you, Lordship.
Yes.
It says, Lordship, if any person having sufficient means
Yep.
neglects or refuses to maintain his wife, comma, unable to maintain herself. So the
Correct.
statute itself is very clear.
That's why I'm telling, this is a
Yes.
interim maintenance.
Lordship,
Correct. You, in the interim maintenance, you file the written objection.
Lordship.
Written after the written objection, only the learned court has passed an order 4,000
But
rupees.
one error has taken place in the said order, Lordship.
What error?
The learned court below has taken my income as 1,50,000 instead of 15,000.
But the court has not passed an order 15,000.
No, Lordship, that's
Court has not passed an order for 15,000, it is 4,000. Correct. So I am disposing of, I am not interfering with this. If both the parties go and.
mediation, Lordship, can
Huh?
be done in this juncture, Lordship. Mediation can be done between these two parties, Lordship.
My lord, but
If
the
they are-
mediation should not come in the way of the payment.
Is there in maintenance in the, as the 498 is also pending? 498
Lordship.
also.
307 read with section 49.
307
Lordship,
against you.
Lordship.
And what about the any matrimonial suit?
Yes, Lordship.
Matrimonial suit you filed.
She has filed.
She has filed.
She has
For
filed for dissolution
divorce.
of marriage.
Divorce
Lordship.
or conjugal right.
No more, no matter.
Divorce.
Divorce for dissolution of marriage, Lordship.
Go for the mediation, can settle
Lordship.
it.
Kindly send it for the mediation.
We can obviously go for the mediation, my lord, but this order should not be interfered with.
No,
and my
that
lord-
cannot be 4,000 rupees. I am not going to interfere.
Yes.
4,000
Because of the
rupees for the
application
wife.
such
this- I don't know how the magistrate given the 4,000.
Lord, I am appearing on behalf of the state, Lord. I have nothing to say. They both are present before your Lord. Husband and wife.
So, Lordship,
Say,
if possible,
which-
kindly
which-
send it before the mediation.
Siliguri, in the Siliguri, any mediators are there?
DLSA.
No,
DLSA is-
mediators are there.
Yes. I'm sorry, my lord, SDLSA.
So and so appearing for the, what is the good name, sir?
I am Sanjay Majumdar.
Mr. Sanjay Majumdar, an advocate appearing for the petitioner.
Follow Lacharji for state.
Colonel Acharji, an advocate appearing for the state. And what's the good name?
My lord, I'm Shubham Ghosh.
Shubhankar Ghosh.
Shubham.
Ghosh.
Shubham Ghosh. An advocate appearing for the opposite party number 2. Police, the petitioner has filed the present application challenging the order passed by the Learned Judicial Magistrate First Court, Siliguri, in miss case number 155 of 2021, dated 11/11/2022, wherein the London magistrate has passed an order directing the petitioner to pay rupees 4,000 per month with effect from the date of filing of the application, being the monthly maintenance to the opposite
Thank
party.
you, Lord.
also. Full stop. This court have considered the have gone through the order passed by the London magistrate and did not find any material, any illegality to interfere with the order passed by the London magistrate, as the said order is only for interim maintenance. Accordingly, the revision application is dismissed. However, the parties to the present application has liberty to take their appropriate stand before the learned magistrate at the time of disposal, at the time of trial of the matter. Full stop. It is informed to this court that the opposite party number 2 has also initiated a criminal case against the petitioner, and the opposite party number 2 has also initiated, I also filed a case for praying for decree of divorce,
Lordship.
praying for decree dissolution of marriage. Accordingly, the London magistrate is directed to refer the matter to the DLSA for appointment of the mediation, so the matter can be.
Lord, it is SDLSA.
SDLSA.
Subdivisional legal services.
Subdivisional legal aid authority, so that the matter can be reconciled by the trained mediator. So and so disposal. Next.
71.
My lord, I beg to appear on virtual mode, my lord.
For the OP number 2, Lordship.
For the opposite party number 2, my learned friend is there. As today, my lord, I want to serve the opposition to the parties.
With
my
for the petitioner? You are appearing. You are appearing in person.
Petitioner, in person number 3, my Lordship.
Petition number 3. What is the application here?
And false case alleged against my family, my
How
Lordship.
many cases may again?
Several matters. Actually, the matter is civilian dispute, and they are doing this case. And there is another matter of my father's forgery case, my lordship. My father is a non-practitioner lawyer since long of Alipurduar court, and his signature has been forged in bail bonds of inside Alipurduar in 2,954 bail bonds, my lordship. This matter has been pending before the division bench of this honorable high court, my lordship. For these several cases and harassments I am facing since long, my lordship. It takes 3 years back. It starts from 3 years back, my lordship. And in this case, my lordship.
What is the case against you?
SC/ST Atrocities Act case against.
And who is the complainant?
My lordship, 50 years old man, my lordship.
Shambhunath Roy.
Yes, my lord. I am for the opposite party number 2, and today we have served. We want to serve the opposition.
Have you received the copy?
No, my lord. Today we filed.
I'm serving the copy.
No, my lord. Today only I have served upon the parties hand to hand, my lord.
My lordship, this case also registered against my minor brother also. He is
Minor father.
13 years old, my lordship.
Minor brother.
13 years old, my
How many cases you are having in this high court? No, in this high court.
Several matters.
This is the only one. Or any other is pending? No. So, okay, you give, will you file the affidavit in reply to this?
My lordship, I want to do this hearing in this circuit, my lordship.
How? You will not file the reply?
I will within that.
Huh?
I will file within that time, my lordship. On
Why?
Thursday.
Thursday. Last week, how them? Okay, you file it. I am granting time. Then let it go to the next circuit. It will take time, madam.
Lordship, several harassments. These effects are gives.
So appearing for the and the petitioner number 3. You are for petitioner number 3. Petition number, and you have made the minor also as a party here.
Yes, him also this.
But it should be through your father or mother. How you can directly be party? What you have completed a law degree. So who has drafted all these things?
Yeah.
What degree you are having?
I am only the honors past, my lordship.
Why you not completed LLB?
My lordship, how, my lordship? These harassments I am facing in the last 3 years. My lordship.
Government college, there is no fees. You can go.
My lordship, time does not permit.
So the petitioner number 3 appeared in person. Full stop. What is the good name, madam?
My lord, Vipsha Datta Roy, my lord.
So appearing through virtual mode for the office party number 2, and Leonard PP is appearing for the state. The opposite party number 2 has filed affidavit in opposition after serving the copy to the Leonard to the petition number 3. Let the same be kept with the record. The petition number 3 prays for time to file affidavit in reply. How much time you want to reply?
My lordship,
1 week, 2 weeks, 2 weeks, huh?
2 weeks. No.
2 weeks. Prays for time to file affidavit in reply within 2 weeks. Let affidavit in reply be filed within 2 weeks. Leave the matter before the next session.
Grateful, lordship.
Lordship, I am appearing for the opposite party number.
Yes.
Opposite party number 2.
Where is the order? Which order? Maintenance? Washing. Under section?
376. No, case diary is not here.
376, nothing.
Against the petitioner, there is nothing. The petitioner number one is the maternal aunt, and the petitioner number two is the Lordship
How
cousin,
many
but-
accused persons?
Lordship charge sheet at 5.
What is the section?
65, 376, 417, Lordship. 34.
Not FOXO.
No.
So why you have kept this in the seal cover?
Because 376.
Yes,
Lordship, I'm praying to file
you are appearing for?
opposite party number 2.
I don't know why in the criminal revision affidavit in opposition, where is the provision? In the criminal revision, it is on the basis of the record. Criminal revision, the court will not go into the third party document.
I need to show some documents.
And what the police,
conduct of the
what the police has seized, only you have to argue on the basis of all three. No special circumstances.
If the quality of the document which is proposed to be shown before your lordship are of sterling quality, then my lord, your lordship has the power to admit them. My lord, the judgment is in
That is there, but you are the opposite
Here,
party.
my lord, here's the petitioner once. My lord, your lordship will understand why she is proposing to file these documents. My lord, here's them once, then we'll say it.
Yes.
Lordship, this
Lordship, I pray for quashing of the.
How many accused persons?
Accused to the 5 now.
Huh.
Out of them,
But you are not included there. Disclose all the document here. You came for the quashing. Where is the charge sheet? Okay, this is a charge sheet FIR.
FIR.
This is a charge sheet. But where are the other documents?
Other documents are given the entire order sheet.
Order sheet can be caused.
No,
You have to bring.
no.
If you are
Quashing of the FIR and charge sheet.
correct, the charge sheet contains the all 161 seizure medical report. How the court will go?
That is the part.
I find here very special circumstances here. You all persons are filing the 482 in every cases, but you are not filing any 161 application, not the seizure list, nor the one other documents which the police has seized.
Copy was not served.
What?
Copy was not served when the application was.
So how the court can help you?
That is a part of case study.
Maybe it is your case. You have to if the case is not been served to you, how you're on the basis of the FIR and the charge sheet, how you make out the 482 without going to the other document in the charge sheet? How? You have to satisfy this. This is the FIR. This is the 161. This is a seizure. No connected. Quash. This is the only thing. No case is made out. You are not given the 161. You are not given the injury report. You are not given the seizure memo. You are not come with the 164 statement. How the court can go into? Then court can see the case diary. I know how the case diary is maintained here. One CD is there. One CD is there. In between, you don't know. Why you persons are filing like this application? Yes, for what document you want to disclose?
Lordship, may I have permission to show these documents? Lordship, this de facto complaint, this victim girl has been cheated not only once, she was cheated on twice occasion. The principal accused, there was a direction passed by Honorable Session Judge that this case is fit for custodial trial in case of the principal accused. On that fear, Lordship, on that fear, these petitioners along with the other accused person proposed the victim girl to marry this person and to file no objection. And accordingly, being a vulnerable condition, being a victim lady, she agreed to their proposal and she filed her no objection and also an agreement. On the basis of such documents, the bail was granted to the principal accused. Thereafter, again, they have done the same thing. They never taken this de facto this victim girl to the matrimonial house.
What is the age of the victim girl?
Now she is 21. Lordship, and thereafter one again complaint has been lodged against all the accused person because they are continuously threatening the victim girl, and whenever she is passing the road, they are insulting the victim girl because they are threatening to withdraw the case. Once she has given, it is admitted.
So have you made a complaint?
Yes, Lordship. This is.
So if you have made a complaint, have you made an application for cancellation of the bill?
Lordship, it is pending against the principal accused.
Against the principal, not the petitioner.
Who has married? Who has married? Principal accused has married.
Principal accused married.
Principal accused has married.
Yes,
This
Lordship.
agreement, the affidavit you are showing,
Yes, Lordship.
this is with regard to the principal
Principal
accused, and
accused.
principal accused is on bail.
Is on bail. But the proposal for the grant of principal accused bail, the other these petitioners and the other accused persons propose the victim girl. This is a trick they have tried to escape from the litigation, Lordship. If it is quashed in state, Lordship, it will create a great adverse effect on the society.
What is the ground?
Principal accused.
Trying to see the involvement of Fisher. They are.
Where is that? Why? That's why I'm asking involvement. How you came to know without the 161? Because the police is not giving the brief fact of the matter in the charge sheet. I don't know how the West Bengal police is working. In the charge sheet, there is no brief fact of the case. Only I visited and consulted the senior officer, filed the charge sheet, case is made.
Here we have the big facts. This is a certified copy of the charge sheet. We have obtained it.
What is your name?
One is the EP Khatmi and two is Bappa Islam. Alias Bappa Muhammad.
Yes, what is the role of this petitioner?
Sure, the case is not here.
That the current, there is nothing. What is the role of the petitioner? Then only 164 and 160 can be given.
Lordship. And Lordship, we find in the case record that marriage was solemnized between the parties.
That's why see her allegation. Her allegation that after the arrest, they came to her and
Did not
convinced
take-
her and married with the main accused. And so
So,
after the
Lordship,
bail, again he has started cheating.
Lordship, whether police has started any case against her upon our complaint on that,
See, that is
that
with
is
regard to
another
the
part.
principle. With regard to what is the role
Lordship.
of this petitioner, that is to be seen.
Lordship.
That what she is telling, that is with regard to the petitioner.
Lordship.
And I don't think there is a
Principal accused.
principal accused, but you are not into why? Please advise the bar. While quashing of the 482 application or 227, you come with the total document.
If the charge sheet is filed, then the statements has to be annexed.
Has to annex.
They file it prior to submission of charge sheet.
Submission of
So
charge-
that's the
how-
problem.
How you can say?
Charge sheet was filed, but copy was not 07.
So you applied for the certified copy. You're not appearing, you might not be. You applied for the certified copy, you will get that. If you are the accused, you will get the certified copy. And your all applications I am finding. That's why all applications are getting dismissed. And how you are preparing the 482 without going through the contents of the 161 or the seizure or medical report?
Yes, Lordship, because copy was not served. This is the thing. Only a fair.
So and so appearing for the petitioner, so and so appearing for the estate, and so appearing for the opposite party. Number 2, opposite party number 3. Who is for the 2?
Opposite party number 2.
2. 2. Opposite party number 2. Position. It is counsel for the state submit that he has not brought the case diary. According case is adjourned, let the matter go. Let the matter be placed before the next circuit.
Grateful, Lordship.
Next,
Lordship, I'm for the petitioner, Lordship.
Half of the state, my lord.
Lordship, I am for the opposite party.
My
Lordship,
lord,
in
this
this
case,
matter,
my lord,
Lordship,
my lord,
Dr.
this case,
Otun Chaudhary will be appearing in this matter, Lordship, due to some personal difficulties. He is out of station, Lordship, praying for 1 day's accommodation only, Lordship.
my lord, may I place some facts, my lord? May I kindly, my lord?
Only 1 day's
But
accommodation.
this is, my lord, they have prayed for accommodation on every single instance that they
No,
have prayed for,
Lordship,
my lord.
all
My lord,
procedures
kindly
have
let
been
me allow
done,
me, my
Lordship.
lord will allow me to place
Opposition
my
has
case, my
been
lord.
filed
I'll
by
satisfy your
ourselves,
lordship,
Lordship,
my lord.
and
I'll
reply
satisfy
also
your
filed,
lordship, my
Lordship.
lord. On
again,
17th of February, my lord.
petition and reply in the criminal division.
Lordship,
My lord, my lord, that's why, my lord,
pending
may I
for
point out,
final
my lord,
hearing,
my lord,
Lordship,
may
kindly
I
1
indicate,
day's
my lord, just,
accommodation
my lord,
only.
kindly allow me
Praying
to
for 1
place,
day's
my lord, just a few, the conduct of the opposite party, my lord. On 17th of February 2025, my lord, they prayed for filing of the opposition. The Honorable Court allowed the such prayer. 2 weeks was given, my lord, to file the opposition. They took 3 months, my lord. On 25th of April 2025, they again came before the Honorable High Court. They said that they will be filing documents.
What is the ground under what is the
My
ground
lord,
for
4
challenging?
section 25 my lord, case has been made out under section 420(506) in a commercial transaction, my lord, whereby in their own complaint, my lord, if my lord produces a complaint towards it's attached with certificate copy, they have made a point that part payment has been done. 4.5 lakhs worth of payment has been done. 2 lakhs by cash and 2 lakhs 40,000 by way of giving back the goods. That is their admission, my lord. My contention is, my lord, that in commercial transaction whereby they have self admitted that part payment has been done, they have made out a case in under section 420, my lord.
Yes.
And my lord, they have filed in opposition, my lord,
Praying for only
whereby
1
they have
day's accommodation,
stated
Lordship.
they have
Dr.
dealt with
Chaudhary-
everything they want to have dealt with, but they have not dealt with any, if my lord sees the annexure of my main application from page 13 to page 18, that shows that I've returned the majority of the goods. They have not neither denied it nor disputed it. They have simply stated all the stories that they wanted to state, my lord. And my lord, they have not at all denied or disputed the receipt, which shows that I've returned the goods against in which and those in the receipts, the vehicle number, the drive number associated with the build world, that is the sole proprietor of the opposite party, they have received it, but they have not at all stated those facts. And my lord, my lord knows that if there's a part payment and their main contention of if the my lord peruses the complaint, my lord will find that the essence, the crux of their complaint is recovery of money. So this is not in my humble submission, my lord, this is not the appropriate forum for recovery of money. They should have gone on to appropriate forum and file appropriate application. They have failed to establish, my lord, that 420 or in 506 criminal intimidation in a commercial transaction. How they have failed to establish that every single instance that
How
they
you
have
find the charge sheet?
Lordship, my submission is there is a dues, and out of that they have
No,
filed
how
fee,
the-
there is
whether
a
the-
recording case.
Whether this is a duty of the
No,
police?
no.
For recovery of
Now-
money.
Now it's up to your lordship. Lordship knows it's up to lordship. My submission is because they filed the 420 and 506, lordship. And there is an allegation that they supplied the goods, and there is some dues and amounting to rupees 14 lakhs something. Out of that, some portion they have. So how you?
My lord, I will kindly see that even that says that establishes the fact that they want the recovery of money, and that should be a appropriate forum before appropriate application before another forum, not this on our High Court, my lord. In my humble submission,
It has been
subject to
filed.
correction, my lord.
Only three, one sister statement recorded, and another is IO and the others. And the charge sheet has been filed here, lordship. And they, I think, charge also be framed.
On the last 3-4 occasions, my lord, they have sought time to file the opposition. They took 3 months to file the opposition, my lord.
Lordship, I'm
Kindly
praying for only 1 day's accommodation, Lordship.
So and suffering for the petitioner, so and suffering for the state, so and suffering for the opposite party number 2. Opposite party number 2. Will you consult for the opposite party number 2 place for time according to Surgeon?
My lord, my lord, kindly keep it on Wednesday, my lord. Will it be my
As a matter of tomorrow.
My lord, kindly keep it on Wednesday, my lord. I have tomorrow.
Tomorrow.
My lord,
Okay.
can it be on Wednesday, my lord?
Fix on 21st.
Lordship, CD.
Grateful, my lord. My lord, kindly, my lord, once
Bring the CD on that day.
small indulgence, my lord, kindly, may I request that no other adjournment may be granted, my lord.
Yes, next. Next.
Grateful, my lord.
Melody, item number 74, Melody.
If you appear on the petition. Okay.
Yes.
In this matter, my lord, I have challenged criminal proceeding which has been initiated against me under section 354 of the penal code. And the defense will demonstrate before your lordship that this is a classic example of how 354 is being used to wreak vengeance and also to concoct malafide proceedings just to have another intention of the de facto complainant to be satisfied. My lord, kindly comes to the petition. My lord.
Where is the FIR?
Yes,
My lord, the first.
Where is the FIR? Where is the FIR?
This is the FIR.
FIR, my lord. FIR will find at page number 38.
This is the FIR.
Your lordship will find the FIR at page number 38. My lord, three paragraph FIR, which will demonstrate, my lord, that the second paragraph, my lord, the relevant I am reading, said such and such always has ill and bad glance toward me and my daughter. Sometimes I saw he always peek at the window when I was slept on bed. But for saving the reputation of my family, I always kept mum myself and did not disclose anything to my husband. In my house, there was a grocery shop, and the said shop was carried by me and my daughter jointly. And taking advantage of the same, said such and such shows some wrong gesture and tried to touch my body and intentionally use force with an intention to dishonor myself. Now, my lord, very, very precisely they have mentioned the ingredients of section 354. However, it does not attract, my lord, I'll demonstrate, my lord. My lord, kindly comes to annex page number from page number 20, annexure A from page number 20, and then page number 23. My lord, what has happened, my lord? May I summarize, my lord? My lord, there is an illegal construction. I happen to be the person who has led the other persons of the locality to file a writ petition. First, representation before the SDM, thereafter a writ petition. The writ petition's order is annexed here, my lord. It was filed before your lordship, and your lordship passed the order in writ petition. My lord, kindly see page number 26. When your lordship was sitting in the writ jurisdiction in 2023, 5th of June 2023, your lordship passed this order where your lordship directed this petitioner to file a comprehensive representation against the illegal construction.
Yes.
Your lordship got it, my lord? Your lordship only directed to file the comprehensive representation, which your lordship will find in annexure A, page number 20.
Yes, I gone through.
My lord, the whole purpose of this complaint is to wreak vengeance, because why did I lead the other residents of that locality to file a representation for removing the illegal building of this de facto complainant?
Yes.
That is the main allegation. Now, my lord, may I refer, my lord Bhajan Lal, just to apprise your lordship as to the criteria of this offense being attracted under
164 was recorded?
Yes, nothing was done.
161 is.
164 was not recorded.
Nothing, my lord.
Where is the other witnesses examination?
161 at page 6 and 7.
That is the victim. But where is the, is there any other person?
Yes, my lord.
Where is
one
that?
Pintu Palan
Huh?
is there. Statement of 161 of one Pintu Palan. Page 6.
Page 6.
6.
What is stated? You supported the prosecution? This is a Bangla language. You have a translated copy?
No, my lord, I don't have it. My lord, I have not been.
How many witnesses? You are having the independent witness?
That is there, my lord.
My lord, a close scrutiny of the FIR would reveal that the ingredients of the 354, first is the ill intention, the use of force with an intention to outrage the modesty of a woman. My lord, your lordship will not find that in the FIR. Now, my lord, why this FIR was lodged? My lord, the 7th criteria of Bhajan Lal,
including the police,
I fall under that.
is there as per the charge sheet.
Yes.
Eyewitness is there.
5, who are
Five
they?
witnesses are there.
That's why, what is the 161? What the witness stated in the
You have
161?
translated forward, don't you?
No, I have.
What they have
At
stated in
presently,
the
I have not.
160?
Then we not keeps it at 12 minutes.
What they have stated in the 161?
Page 7, Milord. Can I read, Milord?
Come after lunch?
Well. With a translated copy, Milord?
Yes.
Yes. All right. So, hey, এটা page থেকে এটা white page থেকে 750
এদিকে, এদিকে।
একটা white page দিয়ে 750 আরে এখান থেকে নিয়ে রে white page টা কি করছিস ছাড়িলা বলি কেন ওনার কাছ থেকে একটা white page
এনে, এদিকে।
ওখানে বস আপনি দেখতে
দাঁড়া, আমি দেখছি। এনে, এদিকে।
টিচার কেন লিখছি সম্পর্ক আমি বলি নাই কেন লিখি এটা আমি তো বলি নাই সম্পর্ক ফুল টিচার নেমলি সম্পর্ক from the terrace from the terrace of the same while ওটা সাইডে টেবিলে রেখেছে তো হ্যাঁ মেনশনস নেই নাম দাগ চেক করে দিলাম টেবিলে রাখা করে দিলে না আমাকে দিয়ে দেবে না টেবিলে রাখা ঠিক আছে I inquire. Inquiry inquire about functions. About such allegation to number product. Then inquire about the allegation to behind the
And thereafter, I. I asked him to be aware so that I don't get these kinds of allegations ever again. So that so that I don't get these kinds of allegations ever again. After this on, ever again. After this on, after this on, 2022. They Mondol again came to me and alleged that the state Vishwambar Prasad came to her shop, that the sage Vishwambar Prasad came to her shop and held her hand, full stop. I advise Rinku to apprise this incident before the law and order authority, before the law legal authority, before the that I have not seen any of these incidents from my own eyes. Before the lake in Nam Lake. I have not seen any of this. I have not seen any of this. This one is my own. I think the for like so much. For the answering on question put forth by you, that our neighbor Rinku Mondo, as a village, as a neighbor named Vishwambar Prasad, who used to stay at Rinku Mondo. That is to be a neighbor by 80 squares, Sukumata, Rinku Mondo, it will be equal to people. I have not seen any of such thing with my own eyes. I have not seen any of such thing with my own eyes. I have only heard it from তুমি বলবে and the neighbor is here for the movie box. About the incidents of Puri Baba Bite, I don't know anything. I'm going to go and I don't know anything. I don't know anything, and I don't have anything else to say. Say, if I get a copy type for print. How to pass the এবারে লিঙ্কটাকে টাইপ করো পুরো টাইপ করতে হবে না টাইপ করতে পারবে তুমি প্রসিড করো টাইপ করে কেন এই আর নাই তো এখানে তো বেশি এটা কিন্তু শিশুদের সঙ্গে রিট সঙ্গে ঘটনার পরে রিট সব আগে ওটা আগে এই রিট করার পরেই তো এগুলা করবে তুমি দেখো না রিট হচ্ছে 19 টাকা রিট হচ্ছে 19 মার্চ পিটিশন দিলে একটা কোনি তারিখ আমি তোমাকে বলছি মার্চ পিটিশন হ্যাঁ 20 তারিখে 22 তারিখে কমপ্লেইন করবে তুমি দেখো তোমার কমপ্লেইন এমনি কমপ্লেইন 21 তারিখ হ্যাঁ 21 আমি 20 তারিখে মার্চ পিটিশন দিলাম আর 21 তারিখে কমপ্লেইন করবে তুমি বাস তাহলে 20 তারিখে আমি মাস পিটিশন দিলাম আর 20 তারিখে এসে আমার হাত ধরে বলতে আসো চলো তোমার সাথে আমি সাথে কাজ করব সেম হ্যাঁ এইটা হাত ধরে যাই কমপ্লিট করবে হ্যাঁ আর ওকে নিয়ে গেছিলাম তারপরে রিডটা কবে করবে রিডটা তুমি রিড আগে এটা অর্ডার আছে কোথায় আমার পিটিশনের পেজ নাম্বার 26 এ আছে 26 কত রিড হচ্ছে 5/6/2023 রিড 6 মাস আগে রিড 6 মাস পরে ঠিক আছে মার্কস পিটিশনটা সেম মার্কস পিটিশনটা হচ্ছে যেদিনকার ইনসিডেন্ট করা এর কথা বলা হচ্ছে সেদিন হ্যাঁ এটা তো সেম হ্যাঁ এই মার্কস পিটিশনটা কোন দুই নম্বর পেজে আছে আমার এটাও ভাগ করা এটা হয়ে গেল আর এর পরে বাবা যে এরা আরো কতজন আমার উইটনেস আছে 25 নম্বরে তুমি আমার উইটনেসদেরকে পাও না মার্কস পিটিশনটা করি না 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 নয় তুমি কুড়ি দেখো না তুমি পেজ 20 দেখো হ্যাঁ পেজ 20 এটা তো ইয়েস এটা আমার পিটিশনই তো ব্লক ডেভেলপমেন্ট অফিসার এটা মাস পিটিশনই একটা নয় বলো এবার তারপরে তোমাকে দেখা 20 তারিখেও আমি একটা এটা তো পিটিশন তিনটে কনফারেন্সে দিলি বলতে রিড করতে বলে দিল হ্যাঁ সেটা হচ্ছে অপশন যাবে এসডিও কে বল এসডিও কে আমি দিলে একটু আপনারা কিছু ডেমোলিশ করব ডেমোলিশ করব না ইন দ্য মিনটাইম ওই কম্পিউটার করে রাখলো টু রেক বেঞ্চ তারপরে কি যদি ধরলা শুনে দেখে মাস ধরলা হ্যাঁ নিও ওটা নিও দেখো কেন কি আছে সিঙ্গেল মিস্টেক দরকার এটা কি আছে কাজ আমি জানবা আমরা যাইনি তো Hello. 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 হ্যালো, তুমি সাহেবকে বলবা আরে আমার কথাটা শুনো আগে, তুমি কি এখানে দৌড়াবো আরে তুমি সাহেবকে দাসুনি দিয়ে দোকান আগে পাঁচ হাজার নিতে বলবা হ্যালো হ্যাঁ वो फ्री नहीं जाने ना এই রকম চিজের দিকে বিজনেস করতে হয় এই দিকে যেটা নিউজ এর কারণে হয় মাত্র কি একটা এটা নিচে ওয়ান ডে সরি পাঁচ ওয়ান গেল পাঁচ ওয়ান ছেলে করতে अनंत ग्राउंड बना के जाए लेके
यस कॉल करो मैटर कॉल कीजिए पासो नेक्स्ट
I am for the state.
May I take your lordship? Only 3 documents.
You are for the petitioner?
Petitioner, lordship.
115, 74, 103.
Only that, that proclamation part.
Yes.
Kindly, Lordship says page 12, that is the written complaint. Dated 11/8/2024. Now, Lordship, page 14, charge sheet was submitted. Charge sheet was submitted.
Charge sheet under same section.
Lordship, charge sheet under.
Same section. Yes.
Same section.
Then
Against two accused persons, including the petitioner. Subsequent.
how many accused persons are there?
Two.
The Lordship only says page 20. Order dated 20/12/2024. And I raise my case.
2012.
Lordship,
Page?
page 20, and extra people.
Yes. You are Gani.
Lordship.
Abdul Ghani is already enlarged on bail.
You are?
Monirul Islam.
Monirul Islam.
You are Manirul Islam.
Lordship.
ER of WS received against IC Rajgan.
No ER.
No ER.
You have stitched that, no. Yes, no ER of WS. Therefore, court is of the view that work is unlikely to be executed soon accordingly. Proclamation against the said accused.
Lordship.
Yes.
Best. I just make this. Next part is regarding that Abdul Ghani.
Actually, Lordship, this is a case under section 302. There are two accused persons, Abdul Ghani and Monirul Islam. Abdul Ghani it's true that already been enlarged on bail. This accused was absconding, no doubt, and but here it's a little bit technical fault. Technical fault.
No ER statement proclamation, Lordship, and see the observation. Court is of the view that WA is unlikely to be executed soon. (82 CRPC, Lordship).
And in the next order, again no ER of WP is received, proclamation issued.
And Lordship, in the order dated 20/12/2024, next date is given on 3rd January. Minimum 30 days time
Is required.
specific place, nothing is there in the order.
Yes. What can be done?
Actually, the accused is absconding. It's the case of 302.
Court is not going to recall the WA, only proclamation.
Yes.
Your police, in the charge sheet, you are absconded accused person.
Lordship, they have shown.
Shown absconded.
Lordship. And RFSL report is not received, supplementary charge sheet will be submitted.
Might be. Where is your name? Absconded?
No, actually.
Page 18, Lordship. The part of the
police prayed for WA.
Married Islam, both the Purban district and trial open, I pray before W may be issued.
WA.
Absconded accused.
WA was issued, but on the very next day, no ER and proclamation directly.
So suffering for the petitioner. So suffering for the state. The petitioner has filed the present application challenging the order passed by the page number
Lordship, 20,
passed by the
CJM Jalpaiguri.
passed by the learned Chief Judicial Magistrate, Jalpaiguri, being order number
Order dated 2012.
being order dated 22. There is no number of the order.
Lordship, no.
Order dated 2012-2024 in GR case number 3922 of 2024, wherein the London magistrate had issued proclamation.
বুদ্ধ অর্ডার চ্যালেঞ্জ হয়েছে না 3/1/2025
এটা আমি subsequent order.
Had issued proclamation against the petitioner on the ground that the WA warrant of arrest issued against the petitioner was not executed. Counsel for the petitioner submit that when the warrant was issued, counsel for the petitioner submitted,
Lordship, after charge sheet, sir.
the police has submitted charge sheet.
7/11/2024
7/11.
2024
The police has submitted charge sheet against the accused, showing the accused as absconding accused person, wherein the investigating officer has prayed for issuance of warrant, and on receipt of the charge sheet, the London magistrate has issued warrant of arrest against the petitioner on 7/11/2024. 7/11/2024. And fixed the matter on 20th/12/2024. On 20th/12/2024, the warrant was not executed, and the London magistrate has issued proclamation against the petitioner. This court find that though the warrant and though the police has submitted charge sheet showing the petitioner as absconded accused person, and as per the prayer of the and on receipt of the charge sheet, the London magistrate had issued warrant of arrest. The warrant of arrest was not executed, nor any report is submitted. Neither the police, neither the investigating officer or the prosecution has prayed for issuance of proclamation. In spite of the same, without following the procedure as prescribed under law, the London magistrate has issued the proclamation against the petitioner. In view of the above, this court find that while issuing the proclamation, by passing an order of proclamation against the petitioner, the London magistrate has not followed the procedure. And as such, the order dated 2012-2024 and subsequent orders is required to be set aside and passed only with respect of the issuance of proclamation against the petitioner. Full stop. The order dated in view of the above, the order dated 2012-2024.
objection one is objection of the state.
The Leonard PP, Leonard advocate appearing for the state submit that during the investigation, the investigating officer has raided several places for affecting arrest of the petitioner, but all was in vain, and subsequently the investigating officer has filed the charge sheet with the prayer for issuance of warrant, and the London magistrate has issued the warrant in spite of the issuance of the warrant, the petitioner failed to in spite of the issuance of warrant, the warrant could not be executed, nor the petitioner has surrendered before the court, and thus the London magistrate has no other alternative to issue proclamation. He submitted issuing the proclamation, the London magistrate has not committed any illegality. इसको बीच में आएगा. In view of the above, the order dated 2012-2024, issuing proclamation against the petitioner is set aside and passed.
One second. And this is order dated 7/11/2024. I have and it's a certified copy. Charge sheet was submitted, no warrant was issued. Next order 8/11/2024, no warrant. Next order, Lordship, I have annexed all the orders. 22/11/2024, no warrant issued.
Where is the order?
Lordship, I have annexed all, it's certified copies. 7/11/2024.
Lordship, in the order, Lordship has just now passed, warrant of arrest dated that date is not actually, we are not finding. Let's look at the charge sheet.
Received the original case record with the copy of the session. 7-11, there is no warrant.
Then 8-11 next order.
No, there is no warrant.
Then 22-11-2024.
We don't do. When present, produce the case only, see has been issued. Like is taken. Cognizance is taken. What is the case record? Considering the aspect nature bail prayer is stand rejected, the accused is remanded to JC. Today for protection of the accused from JC and ERFWA. Against whom?
Where is the WA?
Upper आओ, first में the petitioner has filed an application praying for क्या बोला? Passed by the London magistrate. Dated 2024.
Lordship, perhaps warrant of arrest has been issued before filing of charge sheet.
Dated 22/11/2024, wherein the London magistrate has issued proclamation. The petitioner. Police staff. क्या लिखा उसके बाद?
না হতে পারে
On the that
আমার কাছে দিয়েছে আমার কাছে দিয়েছে
नहीं वारंट का 2012-24 है ना 2012-24 wherein the London magistrate issued the warrant proclamation against the petitioner on the ground that the warrant of arrest could not be executed. ठीक है उसके बीच में करो हाँ ठीक है फिर आगे क्या बोला warrant could not be executed then पूरा काटो तो मैं दोबारा तुम पढ़ा ही नहीं सकते हाँ police has filed a case against the petitioner showing the petitioner as absconded accused person accused and then warrant against the
WA তো 7-11 আছে আর একটা নেই
No, वो वहां से काट दो उसको उसका वहां से पूरा काट दो खाली एक पैराग्राफ क्या क्या करेगा हमको समझ में नहीं आता this court find that पूरा काट दो हटो the petitioner has filed the present application challenging the order passed by the London Chief Judicial Magistrate Jalpaiguri dated dated 2012-2024 in GR case number 3922 of 2024, wherein the London magistrate had issued proclamation against the petitioner. Counsel for the petition submitted that the police has submitted charge sheet against the petitioner by showing the petitioner as absconded accused persons, but the petitioner was neither arrested nor any warrant of arrest was issued, but the London magistrate had directly issued proclamation against the petitioner without following the
warrant issued on 22/11/2024.
ERFW against whom?
Yes, yeah.
Against whom?
No, 22/11.
Correct. 22/11, considering the aspect nature of alleged offense, prayer for bail is stand rejected and accused remanded. To date for production of the accused.
No, that is another 22/11/24.
24, yes.
22/11. Cognizance is taken. Offense punishable under section 115, 103.
Hence warrant of
hence issue warrant. Hence issue warrant of arrest.
ऊपर जो लिखा है
एगन आज
सब ठीक है उसको काटो मैं
hence issue warrant of arrest.
नीचे इसको हटा दो अभी जो तुमको हम डेक्स वो हटा
hence issue warrant of arrest.
लास्ट क्या बोला is no illegality क्या बोला लास्ट वर्ड पढ़िए
আপনার এটি করতে গিয়ে গন্ডগোল করলে হবে?
CRM number so is disclosed. Yeah, full stop. It is made clear that this order is this order is passed by setting aside the order for issuance of proclamation only on the ground that the magistrate has not followed the procedure as prescribed in the law. But the magistrate is at liberty to take appropriate step for issuance of proclamation in accordance with law. नहीं कॉल करो.
I am for the state laws.
Yes, what is the case about? Yes. What is case under section?
498A.
Why not? Yes, madam, what is the case? Why? So he knows the matter is fixed today. Where he is? Not today.
Item number 77 and appearing on behalf of the petitioner. Should this is a CRR against the order, final order and judgment of an MRC pending before the London Chamber of Commerce.
Yes.
Paying for enhancement of maintenance.
Paying for enhancement of maintenance. You are for the wife.
I am for the wife.
Yes. Who is for the respondent? Wife? Who is for the respondent husband?
It does not appear yet, but they have been served.
You should notice.
Yes, okay, they have been served. Lordship, this is a matter, previously, this is a matter. When the final order, the part in the year 2022 September. Final.
Where is the forwarding letter? Prashanta Das.
Was served at his shop, in
Item
in our
delivered.
market.
Item delivered. Yes. Where is the order?
The order is there annexed to the petition. Lordship.
Passed by Leonard
Came first Shilling.
Siliguri. What is the order? What amount has been awarded?
The amount awarded was that of 6,000 rupees. My contention is that I am unemployed widow lady.
6,000
sorry, I'm
rupees.
Unemployed old age lady. I'm subject to various medical treatments. As such, I am trained. I also have.
What the husband doing?
The husband, Lordship, he has a very successful shop in the business. He has a very successful business shop in the Vichal market, Shilimuri. And my contention at the time of filing the case back in 2011, it was also mentioned in the petition. That time itself he was earning around 1 lakh rupees. Currently it's well above more than it's around 1.5 to 2 lakh rupees. It's estimated. That's what I am contending.
So where is the evidence that how you improve the income of the husband?
Lordship, he himself has at the time of filing.
Where is that you approve the income of the?
Lordship, he has filed assets and liabilities declaration, Lordship.
Sir, this is on merit. It was final order.
Yes.
After the evidence, it is the duty of the petitioner to prove the income. Where is that evidence? Show me.
Lordship, I have stated in my assets and liabilities affidavit, Lordship, that he earns around 90,000 rupees, 90,000 to 1 lakh rupees. And I've stated that in my assets and liabilities declaration. And he, however, on the other hand, has contended that he earns only 25,000 and his liabilities are 20,000. It's completely unbelievable. There's a person who earns 25,000 has liabilities himself of 20,000. He has no other person in the family. Lordship, the petitioner and the opposite party, they had a daughter. Such was the nature of their marriage and such was the torture that whatever the petitioner had to bear, she had to bear. Even the daughter, the major daughter, she had to commit suicide. Also, Lordship, there was, if Lordship will kindly see the nature, the conduct of the opposite party. Multiple missed cases had to be filed in order to execution cases in order to retrieve the amount, the interim maintenance. Previously, it was awarded at 5,000 rupees. Even then, they had to, he did not pay, multiple missed cases had to be filed.
What order is passed? That the case arising of the application filed by the petitioner under section 25 is dismissed.
Yes, sir.
Then the petitioner do get maintenance allowance herself for the monthly rate of
6,000 rupees. 6,000 rupees.
So when it is rejected,
After
how
dismissal.
6,000 you will get?
No, Lordship, 6,000 was granted as the final order of maintenance. Interim maintenance was 5,000.
Kindly come to the inner page 10 of your certified copy of the order.
Yes, sir.
Ordering portion. You read the ordering portion.
That the case arising from the application filed by the petitioner under section 2127 is dismissed in contest, but with the orders to call.
Then
The petitioner do get maintenance
How?
allow for herself monthly rate of 6,000 rupees.
The 125 is a maintenance petition which is dismissed.
so once your maintenance petition is dismissed, how the court magistrate has granted 6,000 rupees to you.
Lordship, no, what the order says out here is that she's liable to get 6,000 rupees. It was dismissed, the petition was dismissed, the case was disposed of. That's what the learned.
Petition dismissed, case disposed of, granted maintenance.
Lordship, I think this is a seemingly clerical error, Lordship.
What?
This was just a typing error because there was a specific direction to provide 6,000 rupees of maintenance. The case was disposed of. That's what it made.
The above mentioned period in view of the interim order, this case will adjusted. Obviously, the director will pay the maintenance to the petitioner within 10 days of the section. Failing with the petitioner will revert it, execute the order of maintenance. Interim order stand.
Dismiss is allowed. Typographical.
Lordship, the case was disposed of. That's all I'm.
Now again, interim order is vacated.
Interim order was 5,000 rupees. Lordship. That was and
Prior to that, you read the prior order, prior paragraph. Interim order pass will be adjusted
Stands-
in the areas.
Now stands vacated.
Lordship, it's adjusted. There was already pending. There were many of the amount was pending from the previous. The cases, the certain amount of the arrears is still pending, but the amount of 6,000 rupees was granted. Lordship. That's all I'm contending.
So let this order be sent back for further adjudication.
Not clarification.
There's clearly ambiguities are there.
Lordship,
I am dismissing this application, observing that and giving liberty to take appropriate step before the magistrate.
the opposite parties, the conduct of the opposite parties, sir, that they don't even appear, they don't even receive the notice, they later on giving the money.
And for the
Okay,
state.
not receive the
Lordship, then
magistrate.
kindly fix it on Wednesday, let me come back with
What?
some more materials.
How this court cannot, other than.
Kindly give me one last opportunity, kindly fix out Wednesday, let me come back with more material.
What? For what? You tell me what?
Let me see necessary instructions.
What instruction? This is a point of, this is a revisional application, you come on revision, the court itself find that is an illegal order. Dismissing the application, allowing you to, allowing the 6,000 rupees, dismissing, allowing the adjustment of the interim order, interim order is
Stands
vacated.
vacated. Self-contradictory, yes. It will not help you even.
Yes.
If your petition is dismissed, what order will you give? Take a tick out of it again.
So suffering for the petitioner, suffering for the estate. Petitioner has filed the affidavit of service showing the service upon the opposite party, but the opposite party failed to appear in spite of service of notice. Let the affidavit opposite party number 1 come. क्या बोला? So suffering for the petitioner, so suffering estate. Petitioner has filed affidavit of service showing the service upon the opposite party number 1. But in spite of service of notice, opposite party number 1 has not appeared in the matter. Full stop. The petitioner has filed the present application challenging the order, challenging the judgment. And this is the judgment of the magistrate, final judgment. How you invoke the provision in the High Court? Why you are not going to the Sessions Court? There is a provision. You persons are not applying your mind. If it could have been filed the session judge, you will get another forum.
482.
Who was giving the idea to all of you? File the present application challenging the judgment passed by the learned. Passed by the learned. Judicial Magistrate First Court Siliguri dated 9/9/2024, wherein the learned magistrate has passed, the following order. Inverted comma, semicolon, inverted comma, नीचे ये आएगा यहाँ से लेकर के यहाँ तक के. This court has perused the judgment passed by the London magistrate. In first paragraph of the ordering portion, the London magistrate has held that the application filed by the petitioner under section 125 CRPC is dismissed on context, but without any order as to cause. Immediately in the second paragraph, the London magistrate had passed an order holding that the petitioner to get maintenance allowance for herself at the monthly rate of 6,000. Again, in the third paragraph, the London magistrate has passed an order that any maintenance amount already paid by the opposite party for the petitioner within the above mentioned period in view of the interim order, in that case, the amount will be adjusted with the total arrears amount. And subsequently, in another paragraph, the London magistrate has passed an order that interim order stand vacated. The total order passed by the London magistrate is contradictory in nature. Only on that view of the matter, the judgment dated 9/9/2024 is set aside and quashed. Then full stop. The matter is remanded to the London magistrate for passing a fresh.
Lordship, one indulgence, if I may. The learned James first, the trial court, that court has been like back and forth for a few months, many months. Kindly maybe
Remanded the matter back to the London magistrate for fresh consideration only at the stage of passing judgment.
Lordship, kindly consider last three lines just above the order. Above the order. Therefore,
yes.
Therefore, in perusing all the pleadings and the
Correct, I got
I am of the view that the petitioner is not entitled to get the maintenance.
क्या बोला? Fresh consideration at the stage of argument of both the parties. At the stage of argument parties, and after hearing the parties, the London magistrate shall pass reason and speaking order. Shall dispose of the criminal miscase number.
Miscase number 100
10
2011.
MR case number.
MR
case number 103 of 2011 within a period of 3 months from the date of receipt of this order. Full stop. Learned counsel for the petitioner draw the attention of this court that the post of learned judicial magistrate first class judicial magistrate first court Siliguri is lying vacant for the last several months. If any officer is not posted in the said post, the matter can be assigned to the another London magistrate. Any London magistrate for disposal.
Grateful, Lordship.
CRR so disposal.
Just one, it may be direction may be given to ACM to pick up the or to assign the matter to.
क्या बोले? Be transfer I went to appropriate court will pass. I pass an order if the magistrate will, the other magistrate will the matter will be assigned to the other magistrate for disposal.
That I have to know which is getting assigned to. If the lordship may give the specific direction to the ACGM.
ACGM is not there.
No, Siliguri is subdivision.
क्या बोला? If the London magistrate is not there, is posted, then the ACGM, the London ACGM may take this case of its own or to assign the matter to any of the London magistrate for disposal. Next.
I am appearing on behalf of the respondent, my lord.
Yes. Who is for the petitioner?
I'm for the petitioner.
Yes, what is the, where is the order? What your challenge, sir?
Execution case.
Order dated 7/11/2020.
What order passed?
Past your lordship that
Namely, Sanananja Nandi along with the affidavit of Wakalatnama, realization of the area so and so so and so. Since the petition is produced, have the learned concept of process be requisite not been filed, directed to requisite at once. Then,
your lordship, if you see that the opposite party here, the wife has filed a MR case 106 of 2022, where she had obtained an ex parte order,
correct,
where the direction was given to the husband to pay 6,000 per month
correct,
as monthly allowance.
correct.
Then the wife has filed a MR execution case 276 of 2022 for recovery of 36,000 rupees,
Correct.
where the husband was paying money. After which your lordship would see order dated 23/2/2024 of MR execution 276.
Page number?
22. Lordship, certified copy.
Huh? Order dated?
23/2/2024 of MR execution number 276.
88 page number. 87, my lord.
23?
February 2003.
There's no order.
87, my lord.
Huh?
Page 87.
No pagination. MR case number?
276.
চ্যালেঞ্জ করছে কোনটা তুমি চ্যালেঞ্জ করছে কোনটা সেটা বলছি 140 তো
14/4. 23/2. 2024. No such order is there. You have clubbed all the thing, criminal case, 125 and all these things.
my lord execution case 184 48 1848 2024 order dated 7 November.
He is telling another order, you are telling to no. 23rd February.
Yes, sir.
22. I don't.
My lord, original order not challenged.
How you persons are filing this type of the revisional application? Show! What is the date, sir?
23/2/2003.
So that's why I'm asking, you are telling them. Yes.
Petition was, the case was dismissed saying that petitioner is examined as PW1 discharge. The claim amount of for which he has filed the case is received.
Correct.
2024.
Correct.
Now your honor would find.
What was the total amount? Where is the MX execution petition?
66.
Where is the MS execution through 276 petition?
Your lordship would kindly see the first order. It has been stated that.
Order dated?
Order dated 19/12/2022.
19/12/22.
Second page of the certified copy of 276/2020.
Who has punched this? ये punch कौन करता? This is the way you are filing the certified copy. Give it to him. This is the way. Don't take. Kindly see the order.
উল্টো লাগিয়েছে। কোর্ট থেকে উল্টো লাগিয়েছে।
I am dismissing herein now. You all persons are playing with the High Court. Huh? You all persons are playing with the High Court. Petitioner so and so filed 125(3). Praying for recovery of, that is correct. 36,000 for which period? Which month to which month? Where you got? Where you got? Where is the petition?
At last of the certified copy of MR execution 276/2020.
All. Okay, whatever it means. Yes. Then what has happened?
And your lordship, if you come to the impugned order which I have challenged, your lordship would see that here the order has been passed that along with affidavit of for realization of area of maintenance is consistent with order dated 1/7/2022.
Where is that? Order dated 7/11? Yes. Under section.
Maintenance is connection with order dated 1/7/2022. That is
Correct.
the first MR case.
Correct.
First MR case.
No problem.
Passed by this.
Correct.
Now this. Here the opposite party has paid for maintenance from November 2023 to October 2024. Now the order where the mixed execution 276 was dismissed, here in the during that all the money has been received by the opposite party.
That's why I'm telling that 66,000 from which period to which period?
66,000 rupees lordship from November 2023 to October 2024.
November?
2023
To
October 2024.
October 24. Correct. And this application, where is the application? This 7/11/2024?
Second last. Of the opposite party wife.
November 23 to October 24.
Now this MR execution case 148 has been filed in connection with the MR case number 107.
Correct.
Second MR execution case number 76.
Correct.
Which was dismissed.
Correct. What you want? Have you filed an application before the magistrate?
The magistrate, I
No.
have to the application for the magistrate.
Huh? Where is the order? Your application is rejected? SR and appearance, when you appeared, you could have been shown all the receipt before the magistrate.
As many as 7 to 8 cases are pending against the husband.
Naturally, if you not pay the amount, naturally the warrant will be issued. So you talk to them, file an application, giving the all details, and magistrate will pass our order. But if the magistrate will not pass any order and against you, then you file a revisional application. Yes.
My lord, they did not pay any amount.
What, 66,000? And you have withdrawn the case, you have received the amount, then again you file the application.
Did not pay any amount.
What is the order is wrong? The 66,000.
66,000, my lord, I am the wife.
I
claim 66,000. But
you have
they
received.
Did not pay. Kindly show the money receipt. They did not any money, my lord.
You
They
go
did not challenge.
before the magistrate,
My
sir.
lord,
You are not
did
appeared that the
challenge.
warrant was issued. The case was fixed today, the OP appeared today along with the Wakalatnama filed petition making payment. You are admitted for making payment. You are not filed any application and you come before the court, the magistrate is not hearing. Where is the application before the magistrate that this amount has been paid and this amount she has not claimed and she has withdrawn the application, she is not entitled for that maintenance? Where is that? High Court is very easy for all of you.
My lordship, actually, the husband is facing tremendous problem in that Calcutta court because 7 to 8 applications are pending and most of the time the wife comes and withdraw the cases. If she gives no objection.
So and so appearing for the petitioner, so and so appearing for the opposite party. The petitioner has filed the present application challenging the order dated 7/11/2024 and 26/11/2024, wherein the London magistrate, on receipt of the application filed by the opposite party wife for execution of the order passed by the London magistrate in MR case number 106 of 2022, dated 1/7/2022. It is found that after issuance of the summons, the petitioner has entered appearance and prayed for time for making payment. Accordingly, London magistrate has fixed the matter on 29th of January 2025 for making payment ID warrant. And on 29 January 2025, the case was fixed. Both the parties were present. But the petitioner has not paid any amount. Accordingly, London magistrate has issued the warrant. Full stop. Today, when the matter is called, counsel for the petitioner submit that the petitioner has made several payment in terms of the execution case filed by the wife, and again the wife has filed the present application, though there is no dues. Full stop. In view of the above, this court find that this court cannot adjudicate the issue raised by the petitioner in the revisional application. According the revisional application dismissed, however, the petitioner is liberty to file an appropriate application, file appropriate reply before the London court, before the London magistrate, specifying how much payment has been made, and if any application is filed by the petitioner, the London magistrate shall dispose of the same in accordance with law.
Get through, my lord.
Item number 79.
79 minutes. Direction was upon the state to serve the private respondent, private officer.
Yes. Yes. Filed.
It was direction upon the state.
So you have served the copy to the state for serving. When you are served?
Last occasion itself in the court itself.
Yes. Notice served upon this opposite party.
My lord, CD was also called for, but it was that later notice be served upon the opposite party, including the state.
No, petitioner is directed to hand over the copy of the revisional application along with the annexes upon the London additional public prosecutor appearing for the state. Let the matter place before the next circuit. The additional public prosecutor requested to serve the notice upon the private opposite party through the jurisdiction police station. Order dated 9th April 2025.
Well, we already handed over, so it has not been served.
Not received the
No, we have
acknowledgement.
not acknowledged also.
So and so suffering for the petitioner, so and so suffering for the state. Police stop counsel for the state place for time to ascertain whether the notice is served upon the opposite party or not. Opposite party number 2 or not. In view of the above cases adjourned, let the matter appear before the next circuit. Next.
Item number 3. Your lordship be kind enough to take up the possible matter to not.
Once you lost chance, you wait.
Your lordship is directed to take up the.
Yes, call the matter. 80.
I'm for the state, my lord.
For the petitioner.
Yes.
Take up from the marriage.
Ah.
The petitioner and the complaint were.
So you married?
I married another place. Complaint also married another place.
So what has happened now?
I think starts to be complaint. There was a long-standing relationship since 7 years. The complaint itself is that. The complaint itself is that since last 7 years they were in a relationship. And thereafter the complaint law.
What is the section?
375.
376. 490. And 314 as well as here.
Why 314?
There is the allegation that there is a miscarriage.
There's a medical report.
There is no medical. And the lordship, the complaint was lodged in the year of 2008. Charge sheet filed in the year of 2017.
For the medical report, my lord, CD is required.
Whereas cognizance is also taken on in the year of 2024.
Good. 376.
There is no.
So where is the, you, only you again 2 pages charge sheet and quashing. The court will pass the order in a. What you persons are doing?
লিখতে হবে অ্যাপ্লিকেশনের সময় না, শুধু চার্জশিট অ্যাপ্লাই করলে হবে না। You have to apply for the 161 statement, Caesar list, everything. You have to annex with the.
So and so suffering for the petitioner, so and so suffering for the state. Counsel for the petitioner place for leave to file supplementary affidavit by disclosing the copy of the statements recorded by the investigating officer during under section 161 of the CRPC, Caesar list and other documents which the prosecution has relied in the charge sheet. Let the supplementary affidavit be filed by disclosing the document within 2 weeks from date after serving the copy to the London counsel for the state. List the matter before the next circuit bench.
Sorry, there may be a short stay for the timing.
But that's why without the document, how can?
Kind of short stay for timing.
No, sir. Prima facie has to prove. Yes, next.
I didn't know 81.
Lordship, I'm for the state.
Yes.
Yes, Lordship. Case ID is there only, Lordship.
Challenge the proceedings under section 198.
Yes.
The brief fact of that is that lordship and the marriage sister-in-law is residing apart where before the marriage of this defect case. Happening marriage seems like 8 years back before this marriage. Now they filed a DB application.
Filed a?
DB action, domestic violence.
Against you?
Against me and my husband.
Where you resides?
I reside in my husband's place.
Where?
In Matigara.
Apart from.
Now, lordship, I came before the honorable high for quashing of the matter was quashed. It is in page number 35. Lordship, I'm happy to inform. Page number 35. Now the findings of the court is in page number 30.
Since it is in the petition never shared the household complainant purpose of living together and we could submit then the case would be not maintainable. How do you understand? Yes, then what is it?
Then 2025.
Correct.
Immediately after quashing, this FIR was pledged. This FIR was pledged. FIR is in page number 28. It was quashed on 12 and FIR was started against me on 23 to 2020. Initially in TV, my husband and I was there. In this,
translated copy is there? No.
I can read out. Here. Shall I read out?
Yes.
বিনীত নিবেদন এই যে 2/12/2018 হিন্দু রীতিমতো সামাজিকভাবে সামাজিক মতে আমার বিবাহ হয় তন্ময় সাহা পিতা স্বর্গীয় রবীন্দ্রনাথ সাহা
Who is appearing for the state?
Mr. Ujjal Loksa.
Lordship, I'm here only. Lordship, in the case ID, there are 3 161. Lordship, kindly hear the petitioner first, Lordship. In the case ID, there are only 3 161 statements. Kindly hear the petitioner first, Lordship. I will submit later, Lordship.
Okay.
থানা মাটিগাড়া জেলা দার্জিলিং এর সাথে বিবাহের পর কিছুদিন যেতে আমার স্বামী ও তার পরিবার আমার উপর শারীরিক ও মানসিক অত্যাচার চালাতে থাকে এবং আমার স্বামী ও আমাকে আলাদা করার জন্য শ্বশুরবাড়ির পরিবারগণ আমার স্বামীকে পরিবার থেকে আলাদা করে দেয় এবং আমার শ্বশুর শাশুড়ি ও ননদ তাদের সম্পত্তির অংশ আলাদা করে নেয় এবং কিছুদিন পর তাদের অংশ বিক্রি করে দেয় প্রমোটারের কাছে আমার স্বামীর অংশে আমি ও আমার স্বামী বসবাস করছিলাম সব অত্যাচার ও অবিচার সহ্য করে তারপর গত 2/10/2022 তারিখে আমার এক পুত্র সন্তান জন্ম হয় যার নাম ইউভান সাহা
এবং বাচ্চা হওয়ার পর আমার স্বামী বিবাদীদের প্ররোচনায় আমাকে অসুস্থ ও শারীরিক দুর্বলতা থাকা অবস্থায় আমার বাবার বাড়িতে রেখে আসে। তারপর থেকে আমার স্বামী ও তার পরিবার আমাকে এবং সদ্যজাত পুত্রের সাথে যোগাযোগ বন্ধ করে দেয়। এরপর আমি নিরুপায় হয়ে আমার শ্বশুরবাড়ি জোরপূর্বক ঢুকি। এরপর বিবাদীরা আমার স্বামীকে প্ররোচনা দিয়ে নিজের বাসস্থানে নিয়ে যায় এবং আমার ও আমার পুত্র সন্তানের সাথে যোগাযোগ ও ভরণ পোষণের পুরোপুরি বন্ধ করে দেয়। সেই সময় আমি নিরুপায় হয়ে আমার শ্বশুর বাড়িতে যে আমার নিজস্ব পার্লারটি ছিল সেখানে কাজ করে জীবন অতিবাহিত করতে থাকি। কিছুদিনের মধ্যে আমি কোনো কারণে বাড়ির বাইরে গেলে বিবাদীরা সহযোগে আমার স্বামী ও আমার উপরোক্ত বাসস্থান ও পার্লার ভেঙে গুড়িয়ে দেয় এবং আমি প্রতিবেশীদের কাছে ফোন মারফত খবর পেয়ে আমি নিজে এসে লড়াই করে ঘরবাড়ি পুরোপুরি ধ্বংসের হাত থেকে বাঁচাই। এই ঘটনায় ভিডিও রেকর্ডিংও আছে। এরপর আমার পার্লার ভেঙে যাওয়ার পরে আমি বেকার হয়ে পড়ি এবং আমার পুরনো চাকরি সিভিক ভলেন্টিয়ারের কাজে পুনরায় অনুরোধে যোগাযোগ করি। এরপর আমার স্বামী আমার সাথে যোগাযোগ করার চেষ্টা করলেও বিবাদীরা ব্র্যাকেটে তাপসী সরকার ও ভারতী সাহা বাধা দেয়। আমি সিভিক ভলেন্টিয়ারের চাকরি করে উপার্জন করি। কিছুদিনের মধ্যে ভেসে যাওয়া ঘর বাড়ি পার্লার মেরামত করে ও বসবাস করতে থাকি। এরপর আমাকে আমার শ্বশুর বাড়ির পরিবার বিভিন্নভাবে শারীরিক ও মানসিক অত্যাচার চালাতে থাকে। একদিন বাড়ির বৈদ্যুতিক যোগাযোগ বিচ্ছিন্ন করে দেয়। এরপর নিরুপায় হয়ে গত 25/9/2024 তারিখে শিলিগুড়ি সাব ডিভিশনাল কোর্টে বিবাদী তাপসী সরকার ও ভারতী সরকার এবং আমার স্বামী তন্ময় সাহা ও ননদ জামাই প্রিয়তোষ সরকার নামে ডোমেস্টিক ভায়োলেন্স অ্যাক্টে মামলা দায়ের করি। সেই মামলার কেস ফাইলিং নম্বর তারিখ এত করসপন্ডিং কেস রেজিস্ট্রেশন নাম্বার এত। এরপর গত 20/2/2000 তারিখে আমার বিভিন্ন সূত্র মারফত জানতে পারি যে আমার স্বামী তন্ময় সাহা একটি বিবাহিত মহিলা নাম পূজা বিশ্বাসের সাথে অবৈধ সম্পর্কে জড়িত। আমার ননদ বিবাদী তাপসী সরকার এবং বিবাদী আমার শাশুড়ি ভারতী সাহা আমার স্বামী তন্ময় সাহাকে ও উপরোক্ত বিবাহিত মহিলা যার সাথে অবৈধ সম্পর্ক আছে পূজা বিশ্বাসকে উপরোক্ত বিবাদীরা প্ররোচনা দেয় অবৈধভাবে বিয়ের প্রস্তাব নেওয়া করছে। আমার মনে হয় বিবাদী গণদের উদ্দেশ্য আমাদের স্বামী ও স্ত্রীর সম্পর্ক পুরোপুরি ভাবে বিচ্ছিন্ন করা ও আমার সন্তানের দায়িত্ব থেকে আমাকে বঞ্চিত করার জন্য উক্ত বিবাহিতা মহিলা অবৈধভাবে সম্পর্ক স্থাপন করার চেষ্টা করে। This is the FIR. I have translated
In the domestic violence case, what is her contention when she was residing separately?
Separate. The domestic violence act, Lordship, it is in page number 31, Lordship.
Correct.
Opposite parties are there, Lordship, in Tanmay Shah, Bharati Shah, Taposhi Sarkar and Priyotosh Sarkar.
Correct.
Address are different. Now,
After 1 week from the delivery of the son,
Delivery
the
of the
petitioner
son,
went to her
petitioner went to
parental
the-
house.
okay, and to take page number, yes, Lordship. 7 is the allegation against.
Alcohol and after the petitioner only further used to buy bottles available on the web. When she went to parental house,
When she went to parental house. As per
after 1 week from the delivery of my son. So son was delivered on when?
On approximately.
So Ramna is on
2/10/2020.
2/10/2022. And she is residing there only,
Yeah.
2022. And domestic violence was filed on
On 2025.
24.
24.
And after that, this was filed.
Lordship. And my marriage is in 2007, Lordship.
2007.
Page 38.
Yes. Anything further?
Lordship, I will rely on some judgments. Can I do it right now or?
Yes, madam. You are appearing for?
Mr. Ujjal Laksam, Lordship.
Yes.
Lordship, I'm for the state. Lordship, in the case diary, Lordship, if you could kindly see, there are what 161 statements, Lordship, of the neighbor, Lordship. Page 10, 11, and 12. Lordship,
Translated
similar
copy?
allegations are. Yes, Lordship.
Translated copy is there?
No,
Or in
Lordship.
Bangla language?
It's in Bengali.
So how it can be?
Lordship.
Where is the?
Lordship,
Yes.
page 10, 11, and 12.
What is stated? What is there?
Lordship, I have to go through.
Lordship,
Read.
Lordship. Lordship, this is a statement of the neighbor of the accused person. আপনার জিজ্ঞাসায় বলছি যে দেবযানীকে আমি চিনি, দেবযানীর বিবাহ আমাদের পাড়ায় তন্ময় সাহার সাথে 2018 সালে হয়। ওদের একটি 2 বছরের ছেলে সন্তান আছে। বিয়ের কিছুদিন পর থেকে তন্ময়ের মা ভারতী সাহা, তন্ময়ের বিবাহিত বোন তাপসী সরকার দেবযানীর উপরে শারীরিক ও মানসিক অত্যাচার শুরু করে। মা ভারতী সাহা তন্ময়ের বিবাহিত বোন শুরু করে। তন্ময় মা ও বোনের কথা বেশি গুরুত্ব দিত এবং ওদের কথার উপরে ভিত্তি করে দেবযানীর উপরে অত্যাচার চালাতো। বিয়ের কিছুদিন পর ভারতী সাহা তাদের সম্পত্তির বন্টন করে নিজেদের ভাগ নিয়ে নেয় ও তন্ময়কে ওর অংশ আলাদা করে দিয়ে দেয়। কিছুদিন পর ভারতী সাহা ও তাপসী সরকার এদের দুজনের অংশ প্রমোটারের কাছে বিক্রয় করে দেয়। তন্ময় ও দেবযানী ওদের অংশে বসবাস করতে থাকে। ভারতী ও তাপসী দুজনে চক্রান্ত করে দেবযানী ও তন্ময়কে আলাদা করার চেষ্টা করে। এক সময় ওদের কথা মতো ছেলে সন্তান হবার পর দেবযানীকে তার বাবার বাড়িতে রেখে তন্ময় ওর মার সাথে থাকতে শুরু করে। এর মধ্যে দেবযানী ফিরে আসলে তন্ময়, ভারতী সাহা, তাপসী সরকার এরা মিলে দেবযানীর ভরণ পোষণ বন্ধ করে দেয়। দেবযানী বিউটি পার্লার চালিয়ে জীবনযাপন করতে থাকে। এক সময় দেবযানী বাড়ির বাইরে ছিল, সেই সময় তন্ময়, ভারতী সাহা, তাপসী সরকার এরা এসে বিউটি পার্লার ঘরের কিছু অংশ ভাঙতে শুরু করে। এই খবর পেয়ে দেবযানী এসে ঘর বাঁচায়। পরে সে সিভিক ভলান্টিয়ারে যোগদান করে বাড়ি ও পার্লার ঠিক করে। তন্ময়, ভারতী সাহা, তাপসী সরকার তারপরেও বিভিন্নভাবে দেবযানীর উপরে অত্যাচার চালাতে থাকে। ইলেকট্রিক বিল তন্ময় জমা না দেবার জন্য ইলেকট্রিক লাইন কেটে দেয়। বর্তমানে ভারতী সাহা ও তাপসী সরকার দুজনে ষড়যন্ত্র করে তন্ময়ের বিবাহ অন্যত্র দেবার চেষ্টা করছে।
When it was done? When the incident was done? Occurred, sorry.
Lord,
When the incident was occurred?
FIR was lodged on 23rd February 2025. Lord.
Correct. When the incident was occurred? Because as per your domestic violence, you left the house of the matrimonial in the year 2022.
Lordship.
Correct. After the delivery of the child, you left the matrimonial home. Then you 2024 you filed the domestic violence against all of you. This court has set aside the domestic violence against the petitioner. After the domestic violence has been passed, now you file the FIR. So when this incident was occurred, if it is in 2008 2022,
Lordship, that has not been mentioned here.
Yes, Mr.
Yes, Lordship. Yes, Lordship. Lordship has gone through the materials of the both the cases. Domestic violence in this case, Lordship. Both the allegations are same, Lordship. Lordship, I'll leave it to the Lordship's court, Lordship, because charge sheet, and in this case, charge sheet is yet to be filed.
Yeah, it did. Yes. अरे उनका दे दो स्टेट को।
Page number 18, Lordship, para 20.
Page number 18.
Page number 18, para 24, Lordship.
Insofar as the affidavit number 2 to 6 are concerned, we find that they have no connection with the matters of fact and they have been dragged to the very rhyme and reason. And when we observe indicated that no substantial specific allegation has been made against the affidavit number 2 to 6 other than stating that they instigate.
You do one thing. I am keeping tomorrow. You give the translated copy of this FIR and you give the translated copy of 3 witnesses.
161, Lordship.
I am fixing for orders. I am fixing for orders. Fixing for orders tomorrow. Bring that. So and so suffering for the petitioner. So and so suffering for the state. Counsel for the respective parties have concluded their argument. The petition is directed to supply the translated copy of the FIR and the state is directed to supply the translated copy of the statement of the witnesses recorded under section 24 and 161.
161.
Let the matter appear tomorrow under the heading order.
Grateful.
Affidavit of service filed by the petitioner to kept with the record.
You two appear for the petition.
I am appearing for the statement, Lord.
But the allegations are under 498A, 406 and 34. Lord, I have the translated copy of the complaint. I'm here, my lord, for accused numbers 4, 5, 6 and 7.
अभी जो hearing हुआ उसको yes.
Petition for quashing, my lord. I'm here for 4, 5, 6 and 7. The first page enumerates the accused persons.
Who are you?
My lord, I am the maternal aunt, 3 maternal aunts and 1 maternal uncle. No allegations against us, my lord, in the written complaint itself. However, my lord, the FIR came to be registered against
Who is for the state?
I am appearing for the statement, Lord.
What is the stage of investigation going
My
on?
lord, charge sheet submitted, my lord. Next, last date was fixed on 10th of March 2025 for supply of the copy, my lord. That 207 of the CRPs. That has been done, I think, my lord.
No, I don't know.
Why not? All the charge sheet file is. Charge sheet file was 15/5/2028.
All the accused individual resides in close proximity each other. Every day, the accused number 1, 2, and 3, along with the other accused, have gathered and hold meeting. Following the suggestion, accused number 1 begins slapping or sleeping. Begins
Lord,
sleeping
sleeping. That is
in the
sleeping.
bed instead of our material bed. Accused number 1 is husband.
Yes.
And 2 is father-in-law,
2 is
mother-in-law.
the father-in-law.
Father-in-law.
Yes. And 3 is the mother-in-law.
3 is the mother-in-law. 3 accused persons.
No, my lord. I am for 4, 5, 6 and 7.
4, 5, 6, and 7. Where is the allegation against 4, 5, 6, and 7?
My lord, only 2 independent witnesses statement are there, my lord. Only 2 independent witnesses there. Out of my lord, total witness number of witnesses 9. Only 2 is the independent witnesses. They are named witnesses. Named these 4 persons.
What they stated?
My lord, they stated, but in Bengali, my lord, they stated relevant portion, my lord. বিপাশা এন্ড গুলশানের বাড়ির আমাদের এলাকাতে বিপাশা এবং গুলশানের বাড়ির পরিবারের ভেতর কি নিয়ে ঝামেলা আমি বাইরে থেকে বলতে পারবো না। আর বিপাশাকে শ্বশুর বাড়িতে না শ্বশুর বাড়ির সদস্য স্বামী সহ যে একটা কেস করেছে আপনাদের থানায় তা আপনাদের কাছেই জানতে পারলাম। One of the independent witness and my lord, another independent witness, my lord, named স্বামী শ্বশুর শাশুড়ি মাসি শাশুড়ি, that is auntie in law, my lord, মেশো শ্বশুরদের নামে মামলা করেছে, that is hard hearsay evidence. These are
মামলা করেছে
মামলা করেছে
জানি না কি হচ্ছে।
Yes, these are the 2 independent witnesses statements are there, my lord, in the entire case there, my lord, out of 9. Out of 9.
The charge sheet has been prepared on 5th of May 2023, but when I don't know when it has been filed and took cognizance of the case, because the cognizance order has not been annexed here. First of all, second is lordship is this, the petitioners, 4 petitioners have taken out this application primarily on the ground that they are residing elsewhere, not at the place of occurrence. But it is my specific case that though they maintain Aadhaar card, voter card from the other state because they have other residence, but they both, all four.
That's correct.
No. Why I?
Where is the evidence? You show me.
I'm showing, Lordship. They, all 4 accused persons, the petitioners, are residing just next door neighbor. They are the next door neighbors. Now the case is this, Lordship. 498A and 406 has been alleged. Lordship, there is a recovery of the Stridhan articles and other things.
From whom?
From the in-laws. From the in-laws.
Correct.
From the in-laws. Now the question is that, Lordship, the seizure list has not been annexed with the charge sheet. So far I gathered from the material a little. And the seizure list has not been annexed. And mechanical charge sheet has been submitted. Most of the articles are still lying with the matrimonial home that are required to be recovered under section 406. But since there is a stay order passed by this honorable court, I could not proceed with the matter anymore before the learned trial court. This is the predicament. Lordship, since all the accused persons are next door neighbor, but they maintain other residence in the elsewhere, they have taken the plea that since they are residing.
I am not on that.
Yeah.
They are residing may America. They reside may in USA.
Yes.
The court is not on that.
Yes.
The court is only has to go through the materials available on record.
Yes.
With regard to the husband, mother-in-law and mother-in-law are not before this court.
Yes.
This court is the other relative of the husband. Correct. Now that's why I put a specific question to the state. Show me the material against this petitioner.
Yes.
There is no. Where is the allegation against these petitioners? You might have been stated in your complaint,
Yes.
but that has to be corroborated by the other witnesses under 498A.
True, but the investigation has
Already completed charge sheet filed.
The charge sheet filed without intimating me, Lordship, because there
Why?
how
Under which provision you are entitled for the charge sheet?
Under 171, when 173 subclause 2, when the charge sheet is submitted and court is taking cognizance, prior to this, Lordship, I am entitled to get a notice.
Under which provision? Show me.
If the court is that is mechanical charge sheet is going on, if the court is thinking that there is no material has been.
Sir, that is only with respect. The police has filed a final report.
Yes.
Then the notice will go to the complainant. If there is no final report, mind it is a charge sheet.
True. But thing is this, Lordship, there is no notice so far till.
Why the notice will go to when the police has submitted the charge sheet? Why the notice? Notice will go to you when the case will be started.
At the time of evidence. At the time of evidence.
What you are telling, sir?
Sir, unless
I have not. Though I am not holding the criminal bench, I have some idea. With regard to
what is calling for your Lordship, I absolutely agree with you that there is no occasion for serving any notice. I am not disputing. I am only saying that unilaterally the court has taken cognizance and the investigating officer filed the charge sheet. So I don't have any privy to this particular occurrence. So that's why I was not aware of the situation that mechanical charge sheet has been filed, and it was necessary to take appropriate action before the court.
Correct.
But I couldn't take it because I was not informed.
Correct.
This is the predicament. Subsequently, when this CRR has been filed, when the notice is served upon us by this court, then I came to know that charge sheet has been submitted and that charge sheet is quite mechanical. And not only that seizure has been made, that seizure list has not been annexed here too.
Seizure list of what?
Of recovery of articles.
From whom?
From the mother, from the in-laws.
In-laws, not by him. Not by them.
They are the in-laws. They are the extended in-laws. They reside just next door neighbor.
Anything has been seized from their possession with regard to your history done.
So I have to check it out.
What check? The CD is here.
The CD is there. Kindly, I don't have.
There's nothing. It is not your case that they have taken your all belongings. This is not your case that they have taken the belongings and they have misappropriated your Istridhan. You can object, but you cannot object beyond the document, sir, beyond the record. It is not your complaint. Kindly go to the complaint. Is there a complaint that they have misappropriated your Istridhan?
No, so far misappropriate is not
Then?
not alleged.
You are telling that
so far-
you are telling that the Caesar list might be.
So far,
You might have been given the car. You might have been given the aeroplane.
not this lordship. So far, the domestic violence is concerned 49801. So 498A is concerned only. I'm restricting.
Correct.
My submission is this: since there is a continuous cause of action by the in-laws and as well as husband.
I am not telling that I am not going into the limitation. This court under the revisional in the revisional jurisdiction, what the court has to see. Court has to see whether the prima facie case has been made out. They can go for the trial, or there is no case. That is the only thing. So that's why I'm again and again telling you to show me where is the increment against these petitioners. You show them, naturally the petition will be dismissed.
So what my learned
The
friend
the state has shown the 3 documents.
Yeah,
They have stating two statements.
statements.
One is telling that only she came to know the case has been initiated. Second is came to know she has made a complaint. That's all.
Yes.
Independent.
That's a true independent. So where is that?
There are several independent interested witnesses are there. My lord, brother, sister, mother,
That is different
father.
thing. So
They are they are corroborating the FIR, my lord.
They are corroborating FIR.
so what can be done?
But independent witnesses not corroborating.
Now, if I may just seek reliance on two judgments. Another fact is important. This written complaint is a counterblast of the divorce petition filed by the husband. That is also important.
Divorce petition, how you connected? The husband.
By the husband, yes. In any case, yes.
Why are you going into that marriage? What is the judgment you are relying upon?
The political matter where the maternal aunts and uncles were not absolved of this. But paragraph 4 of the judgment. Paragraph 4 says, the revisal of the charge sheet and the supplementary charge sheet discloses the fact that the evidence are not the immediate family members of the third respondent husband. They are the maternal uncles of the third respondent. Except the bold statement that they supported the third respondent who was harassing the second respondent for dowry, and that they conspired with the third respondent for taking away his child to the USA. Nothing else indicating their involvement in the crime was mentioned. The appellants approached the High Court when the investigation was pending. The charge sheet and the supplementary charge sheet were filed after the disposal of the case by the High Court. Paragraph 5 here. Criminal proceedings are not normally interdicted by us at the interlocutory stage unless there is an abuse of the process of court. This court at the same time does not hesitate to interfere to secure the ends of justice. See State of Haryana versus Bhajan. The court should be careful in proceeding against the distant relatives in crimes pertaining to matrimonial disputes and dowry debts. The relatives of the husband should not be roped in on the basis of omnibus allegations unless specific instances of their involvement in the crime are made up. It's quite applicable to my case. In fact, in my case, there are no allegations.
Yes.
Another judgment. This deals with the fact about this complaint being a counterblast of the divorce petition. Paragraphs 20 and 21 at page 6. I'm sorry. Paragraphs 20 and 21 at page 6. 20 says, losing hope in the marriage, the appellant number 1 issued a legal notice to the respondent number 1 seeking divorce by mutual consent on 13/12/2021. Instead of responding to the said legal notice issued by the appellant number 1, respondent number 2 lodged the present FIR 82 of 2022 and such, registered with the Neeraj police station under section 498A of the IPC and sections 3 and 4 of the Dowry. Paragraph 21 is important. Given the facts of this case and view of the timing and context of the FIR, we find that respondent number 2 left the matrimonial house on 3/10/2021 after quarreling with the appellant number 1 with respect to her interaction with the third person in their marriage. Later, she came back to her matrimonial house, assuring to have a cordial relationship with the appellant number 1. However, she again left the matrimonial house when appellant number 1 issued a legal notice seeking divorce on 13/12/2021. The present FIR came to be lodged on 1/2/2022 by respondent number 2. Therefore, we are of the opinion that the FIR filed with the respondent number 2 is not a genuine complaint. Rather, it is a retaliatory measure intended to settle scores with appellant number 1 and his family. Not seeking reliance on this judgment, your lordship may very well pause the entire proceeding.
Yes. Anything?
So far the petitioners are concerned, Lordship, as the record itself discloses that what are disclosing from the record, I have nothing to contradict. So far the other accused person are.
Other is not before this. Who are they? Petitioner here?
4, 5, 6, and 7, they are in the written document.
No, you file the application to all. In favor of all.
No,
Hmm.
we put 4, 5, 6, and 7.
So Papaya is
Apia is the maternal aunt.
Aunt,
maternal aunt.
aunt-in-law.
Asadul is the maternal uncle.
Asadul,
Sapna and
maternal
Sapna.
uncle. Yes.
3 and 4 are also maternal uncles.
In Bengali, Masi Shashulu.
All masses also.
And
That is written in the 161 statement. Your Honor.
So one contention may be recorded, Lordship. They have claimed that they are residing elsewhere, but it is, I am strongly
I
contradicting.
record your submission. Don't worry. Your submission is that though they are having the identity card of the different area, they are residing in the locality and they are
Next door neighbor immediately.
next door immediately, and they have pushed the petitioner to commit the offense, and they are
Exactly.
involved in the matter. That is the okay, no problem.
Great.
So suffering for the petitioner, so suffering for the state, and so suffering for the opposite party number 2. The petitioner has filed the present application. Paying for quashing of the criminal proceeding of Puj initiated by Puj Bihar Women Police Station case number 40 of 2023 dated 10th April 2023 under section 498A/406/323 of the IPC, read with section 3/4 of the Dowry Prohibition Act, and the charge sheet submitted by the police being charge sheet number 39 of 2023 corresponding to GR case number 623 of 2023 pending before the Learned Chief Judicial Magistrate 623 of 2023 pending before the Learned Chief Judicial Magistrate at Kuch Bihar District Police Stop. The counsel for the petitioner submit that the petitioner number 1, petitioner number all maternal aunt.
No, no. Except who is the maternal uncle?
Uncle.
Yes.
Petitioner number 1, 3, and 4 are the maternal aunt of the husband of the opposite party number 2, and the petitioner number 2 is the maternal uncle of the husband of the opposite number.
No, my lord, of the defective complaint.
No, opposite husband of the opposite party.
Oh, husband
of the, that's why, otherwise it will confuse. Opposite party number 2. Full stop. Counsel for the petitioner submit that the wife, the de facto complainant, being the wife of the principal accused, has filed a written complaint before the officer in charge Kuch Bihar on 10th April 2023, making a false allegation against. But your name is not here.
No.
How your name has come?
Not because the first page enumerates me as accused persons.
No.
First page of the written complaint.
Being the wife has last name. Wife of the principal accused has filed a written complaint on 10th April 2023, wherein the de facto complainant has indicated the name of the petitioner in the said complaint, but in the written complaint there is no allegation against the petitioner's hearing. But in spite of the same, the police has initiated an FIR for the above offences, including the petitioner's hearing. Counsel for the petitioner submitted After the FIR,
যা বলছে একদিন
counsel for the petition submitted. Even the police
know?
has submitted the charge sheet after the investigation against the petitioner's opponent for the above mentioned, for the offense under section. For the offense under section 498A. ऊपर हम लोग नहीं दिए 498A/406 of /323 of the Indian Penal Code, read with section 3/4 of the Dowry Prohibition Act. Counsel for the petitioner submitted that the petitioners are the maternal aunts and uncle of the petitioner, and they are no way involved with the family dispute of the principal accused and his mother and father. The petitioners are residing separately, and they have no contact with the petitioner. And they have no contact with the wife of the de facto complainant. Counsel for the petitioner submit that though the police has submitted the charge sheet, but even in the charge sheet, there is no evidence to prove that the petitioners are in any way involved in the said offense. Involved in the said case. In the said case. Counsel for the petitioner relied upon the judgment in the case Subbarao and others versus the state of Telangana, reported in 2018, volume 14, SCC 452, and submitted that
Paras 4 and 5.
submitted that merely a bald statement made in support made in the complaint cannot be said that the petitioners are involved in the matter unless and until there is any specific allegation against the petitioners. The petitioner has also relied upon the judgment in the case of Digambar and others, another versus the state of Maharashtra, reported in 2024 SCC online SC 3836 and submits. Here also the notice has been issued.
Yes.
Husband?
Yes.
And submit that.
No, husband has filed the.
And submit that in the present case also, the husband of the de facto complainant has filed an application for dissolving the marriage between the husband and the between the de facto complainant and her husband, and only for the contrablast, the de facto contrablast, the de facto complainant has filed the case involving all the relatives of the petitioner, all the relatives of the husband. All the relatives of the husband, though the relatives are no connected with the above offenses. Full stop. Per contra, learned counsel for the state submit that in the written complaint, the name of the petitioners are categorically mentioned by the de facto complainant, and on the basis of the said complaint, police has initiated an FIR. After initiation of the FIR, police has investigated the matter. And during the investigation, sufficient materials have been collected, which proves that the petitioners are also involved in the matter. And accordingly, police has submitted charge sheet. Full counsel for the state submit that the investigation has been completed. Charge sheet has been filed. Only how many witnesses?
Total witness 9.
Only 9 witnesses are there, and if the petitioners will face the trial, the same will be disposed of as early as possible by the state. He submitted. There are sufficient materials in the case diary, and as such, the petitions are not, and as such, the proceeding against the petition is not liable to be quashed. Learned counsel appearing for the de facto complainant / opposite party number 2 submits that submit that the petitioners are the maternal aunts and uncle of the de facto complainant. They are residing by adjacent to the house of the
Maternal aunts and uncle of the husband.
uncle and aunts of the husband of the de facto complainant, and they are residing just adjacent to the adjacent
to the matrimonial home of the
adjacent to the matrimonial
Home
house
of
of the
the
de facto complainant, and this and the petitioners being the maternal aunts and uncle of the de facto complainant and of the petitioner of the petitioner now and then have instigated the petitioner to क्या बोला? Now and on the instigation of now and then on the instigation of the petitioners, the husband of the de facto complainant has committed cruelty and harassment upon the de facto complainant. Police counsel for the opposite party number 2 submits that there are sufficient evidence on record, and as such, if at this stage the petition, the proceeding against the petitions is passed, the de facto complainant will not get justice. That's all. Police stop. But the learned counsel for the respective parties produce the materials on record. This could find that in the complaint, the de facto complainant has named altogether 7 accused persons. That is the husband, father-in-law, mother-in-law, and this 3 aunts and 1 uncle of the husband. But in this court has gone through the complaint filed by the petitioner, filed by the de facto complainant. In the complaint, the total allegation made by the de facto complainant is against the husband, father-in-law, and mother-in-law. There is no allegation against these petitioners. But even though the name, even in the complaint filed by the de facto complainant, the name of the petitions is appearing, and accordingly, FIR is charged. The police has completed the investigation. This could find that in the charge sheet, the police has cited altogether
11 witnesses.
11 witnesses.
Nine.
No, 9 witnesses. No, 11 witnesses.
Total 11 witnesses.
Altogether 11 witnesses.
Including police witnesses.
11 witnesses, out of which
only 2 witnesses are independent, Malad.
Out of which 2 are the independent witnesses, and 2 are the independent witnesses. This court has gone through the statement of the independent witnesses recorded under section 161 of the CRPC, and this court find that the independent witnesses have not stated anything against this petitioner. As regard the statement of the other witnesses, they have only stated with regard to the relationship of the petitioner, of the complainant, of her husband and in-laws. These petitioners are the maternal aunts and uncle. Full stop. This could find that aunts and uncle. This could find that there is no even indication that petitioners have misappropriated the Stridhan of the de facto complainant. Though the police has invoked section 406 of the IPC, there is no evidence on record to prove that the petitioners have committed any offense against any offense to prove the case under section 498A of the IPC. 498A of the IPC. In the case of Supra, the Honorable Supreme Court have categorically held that the immediate family members of the husband, that is the maternal uncles of the husband, accept the bald statement that they supported the husband who was harassing the complainant for dowry, and that they conspired with the husband for taking away his child in the USA. In the present case, also, it is the allegation that the petitioners, being the maternal uncles and aunts and uncle, have instigated the husband of the de facto complainant to harass the de facto complainant. But there is no evidence on record to prove the allegation that these petitioners are at all involved in the matter. Full stop. Only with regard to the bald statement, the court cannot allow the prosecution to continue with the proceedings, which will end at no fruitful result for the prosecution. In the case of Digambar and another, Supra, the Honorable Supreme Court has categorically held that the husband has issued the notice to the wife, and instead of giving reply to the said notice, the wife have initiated the proceeding. In the proceeding under section 498A. In the present case also, the husband has already initiated a matrimonial case praying for decree of dissolution. And subsequently, the petitioner has filed the de facto complainant has made the said complaint. Considering the above aspect, this court find that this is the fit case wherein this court can invoke the provisions of 482 of the CRPC by quashing the proceeding against the petitioners herein for the offense under section 498A/406 420 of the IPC, read with section 3/4 of the Dowry Provision Act. Full stop. In view of the above, the proceeding initiated against this petitioner by the Women Police Station, case number 40 of 2023, dated 10/4/2023, under section 498A 406/323 of the IPC, and the charge read with section 3/4 of the Dowry Prohibition Act, and the charge sheet submitted against this petitioners being charge sheet number 39 of 2023, corresponding to GR case number 623 of 2023, pending before the Learned Chief Judicial Magistrate, which BR is set aside and passed. The petitioners are discharged from their respective bail bonds.
One line may be added also. The rest of the petition, rest of the accused, the proceeding of the against the rest of the proceeding may be proceeded in accordance with law.
This petitioner Mola,
That's make it clear.
no, it is made clear that it is made clear that in the present proceeding, this court has only considered with regard to the case of Papaya Yasmin, Asadul Islam, Sabina Yasmin, and Sangeeta Yasmin, and this court has not considered with regard to the case of the other accused persons in the charge. Correct.
Grateful.
Affidavit of service, Kapil. Next, PRR disposal.
I didn't know what it is.
Huh?
Probably that case already disposed of.
Huh?
Probably the case already been disposed of.
Case disposed of?
Yes, sir.
By court?
Yes, sir.
Which court?
By honorable, by this court. Man, can see the order.
So how it is again this case?
Second point.
In such way, CRR is according disposal with the direction upon the court below to make every endeavor to expedite and disposal of the case and to make his best effort to conclude the entire proceeding, preferably within a period of 6 months. So and so appearing for the petitioner, so and so appearing for the state. This court find that by an order dated 10th of March 2025, this the CRR number 122 of 2025 is also already disposed of. 80?
84, Mr. Suhito Muzumdar is appearing.
Yes.
He is on his place in court number 1 minute.
Pass over. Next.
If I
Yes. What is the case?
But not the present case. Actually, we have to actually pray for quashing of the sections
85.
85 and 108 BNS lordship. 85 that is corresponding to section 498A and 108 corresponding to 306 of IPC lordship.
Correct.
So in this case, lordship, the most peculiarity of this case is lordship. Here this is one complaint was lost by the father of the victim, Fazlebia, in fact, the complaint here in this case. The complaint was lost on 1/9/2024.
19?
Correct. And
No, 30th number 24.
no lordship. FIR is FIR 1/9/2024.
1st September
1st September.
2024.
Annexure is there, right? Page number 1314, annexure 1.
Yes.
Kindly see. FIR was lost on 1/9/2024 and the incident occurred on 22nd August 2024. So for the allegation is concerned, lordship, after marriage, this is stereotype complaint, lordship.
Who are the petitioner here?
Here petitioners here.
Husband.
Husband and in-laws.
In-laws.
In-laws. So
All are in-laws.
All together 6 petitioners are there. The petitioner number 1, Ramjan Ali Mia is the husband here.
Correct.
So here all together 6 accused petitioners are there. First three accused petitioners were enlarged on bail by the learned session judge Coachbihar lordship. And the rest of the 3 petitioners were enlarged on bail by the honorable division bench of this.
Anticipatory.
Bench. All these accused persons were granted bail by the learned session judge and honorable high court lordship.
What is the ground for challenge quashing?
Lordship. Section 306, that is abatement to commit suicide. So here in this case, no suicide was committed. But the section has been.
She is alive.
She's alive. She was admitted on 22nd August. She was
discharged on
24th. And that has been earlier, your lordship, your petitioner lordship, actually directed the IO to be present before this bench, lordship, and he apologized, lordship. So subsequently, most interestingly, charge sheet was submitted.
Thereafter, after the apology.
No, prior to that, charge sheet was submitted, and charge sheet was submitted under the same section, abatement to commit suicide. Most interestingly, subsequently cognizance is taken by the learned magistrate. That is also section is there. And I come to the next part, that is 498.
Where is the charge sheet?
I have annexure there, lordship. I have made the annexure charge sheet, annexure 5, page number 22 to 25.
Charge is filed. Charge is framed. No.
No.
Yes.
Even thereafter cognizance has been taken by the learned magistrate, lordship.
Where is the cognizance? Cognizance order?
Lordship.
Not enclosed.
That not be enclosed. Certified. I have got the certified copy, lordship. Kindly. That is the page, lordship. That is the page.
She's alive.
Then what is the stage of the case?
This is the no, charge has not been paid, charge has been submitted, completion has been taken. Lord. So this is the case of the scenario of the case. Lord. And most interestingly, she was she was.
Today's file for WS and WO? What? What
That is
application?
different. After 7 days, she again filed one maintenance case. That's a separate case.
Miss case.
So I am just concerned about this 498 and 306 lordship.
Okay, 306 will go.
Go.
What about the 498?
498 lordship, I am coming to that. In case of 498 lordship, enter case was the incident occurred 22nd 8 2024. She was discharged from the hospital on 24th. After 7 days, all of a sudden she rushed to the police station and lost the complaint. These 7 days, there is no explanation why the delay has, why the FIR has been lost after 7 days. Moreover, after 9 days, after lodging the complaint, after 9 days she filed the maintenance case.
Okay, no problem.
So, but the FIR is concerned in repeated, if there is a pattern of judgments of the Honorable Supreme Court with regard to the 498 case, then this cannot be mere just mere general allegations. Because these are this section has been.
Who are the relatives here?
What the relatives?
One is the husband.
One is the husband, Lord.
Second is the father-in-law.
Father-in-law.
Third is
the uncle.
No, second is not the father-in-law.
No,
Who is the second?
Second copy of PB.
No, Ramzan Ali is the husband.
Husband, yes.
Second is?
Others are uncle, aunt.
No, that's why who is the second? Alamgir Mia?
Alamgir Mia is the yes.
Who is Alamgir Mia?
Ramjan Alamgir Mia, Vanapuri Mia. Alamgir Mia. Father Lokman Mia, that is petitioner number 6 is the father of the petitioner number 1.
Petition number?
Petitioner number
5.
6. Petitioner number 6.
Lokman Mia is the 5.
5.
Father.
Sister, and Lokman Mia, that is petitioner number 5 is the father of petitioner number 1.
Correct. Petition number 1 is the father. And 6 is the mother.
6 is the mother.
Mother. And 4?
4
Abia Khatun.
Wife of Abdul Malik. That is auntie.
And Jujlal Mia?
Uncle.
Alamgir also uncle.
Uncle.
Okay. So what was the allegation against these persons? With regard to the 2, 3, 4? 2, 3, 4, what are the allegations, sir? In your CD?
They all together torture upon the.
Where is the evidence?
Now, the several 161 statements there from the statement of 161, their name has been reflected.
That's why, what is the allegation? What name might be? What is the allegation?
They all together.
Because as per the FIR, only 50,000 rupees was demanded by the husband.
Yes.
50,000 rupees was given. Thereafter, the torture was caused, and she has consumed the poison.
Untolerated
Taken to the
physical,
hospital, and
mental
she
torture.
discharged. This is the allegation in the FIR.
Yes, my lord. As per the FIR, my lord.
Yes,
May I read in Bengali, my lord? আসামি নম্বর 5 এবং 6 আসামি বাকি সকলে আসামিদের সব সময় কুপরামর্শ they are insisting the
Correct, that's the FIR. Where is the evidence?
yes my lord 161 statement is there.
164 recorded?
No, 164 not recorded.
Not recorded. Yes, 161 what is stated? Who has stated anything about this uncle aunt? I am not with regard to the husband, mother-in-law, father-in-law. What about this aunts? Come tomorrow, be ready.
They all together torture upon the this is the 161 statement.
What type of the torture? What is the that's why I'm asking. What is the evidence on the CD? Who has stated in 161?
As per independent witness statement, against this petitioner, against aunt, general allegation.
Husband and
father-in-law, mother-in-law.
That's why I'm telling with regard to this.
Yes.
yes my lord.
Against aunt, general allegation.
Mere allegation.
Yeah.
General. So
498
what can
allegation is 498 is there my lord.
that's why come with the come tomorrow with this. Bring this translated copy of this with who are the important witness. That's all on Bangla language.
161 there is no other specific allegation against other aunt.
There's no specific allegation. Okay. Hearing concluded. CAB.
Grateful lordship.
Okay, tomorrow, lordship, tomorrow.
CAB.
Oh, grateful lordship.
You have a CD? You have a CD?
Yes.
Give the CD. CD be kept.
Certified CD is there.
Certified copy of CD.
No,
CD produced by the state be kept in the record. Yes, next. Yes.
One day accommodation requirement of CD has not yet been received.
But in the last occasion, his diary was directed to be put.
Not today.
Lordship. In this case, Lordship, I am appearing. Lordship, kindly fix it on Thursday, Lordship. I'll come there and do it physically, Lordship.
Thursday, the last. Come on, Wednesday.
Lordship, actually, tomorrow is my Lordship. Actually, my there's a problem, Lordship. Actually, Lordship, I'm a father of a daughter, Lordship. Actually, she's quite ill, like Lordship. That is why I need to take her to the hospital tomorrow, Lordship.
No,
She was born
Thursday,
last week. Thursday, Lordship. Thursday, Lordship. Grateful, Lordship.
Yes, next.
Lordship, I am for the petition in item number 27, Lordship.
Item number 87.
87, Lordship.
Yes.
Lordship, this is an application whereby my statutory bail application was turned down by the trial court, Lordship. Prior to that, Lordship, that is the clearly stated, Lordship, I was arrested on 26 November 2024. Subsequently, a charge sheet was submitted by the concerned investigating officer, but that charge sheet was not backed by the IO report as prescribed under section 193 subsection 3.
No, what you are challenge here? 4th March order.
Lordship,
Where is the order?
there's a certified copy of the order, Lordship.
Video band
that I have already.
Where is the order?
Certified copy has already been there, Lordship.
Order dated
4th March 2020.
Then the proclamation order.
Fix for year of proclamation, when the year was issued.
There was explosive one.
Record is put up. Declare holiday on account of Ram Navami. No steps by the accused persons. No year of WA against the when the first year of was issued. Today is fixed for year of WA.
Yes, 28th of February 2024.
28. Today is fixed for hearing of the cognizance of the IO report. IO of this case present before this court, hearing so and so, IO of the produce CD. Cognizance of IO report is taken on this day. Warrant of arrest is pending against the one accused person. In this case, let the matter be kept for ER of WA. Then ER of WA, 2nd March.
2nd of March.
2nd of March, ER of WA. No year of WA will respect a warrant. Accused objection. Then ER of WA continue.
Then 18th of April.
Huh?
18th of April.
Then 18th April, record is put up. 7th April declared holiday. No steps. ER of WA against the accused of Asraf. What is your name?
My name is
Asraful.
Alam.
Correct. IO and CB KZ adjourn. ER of WA. No problem.
10th of May.
10th of May, year of WA, since IO is directed to present before this court on the next date, so cause as to why action should not be initiated in for duration, what they comply with the order. When the matter is fixed, receiving the execution report of the said warrant, the conduct the IO is not serious mandatory investigation. Let the copy of the order.
Then the include order also. 31st of May. Then the include order. 31st of May 2024.
21st of May. IO of the case is present before this court. Yes. Any on the regarding the warrant of pending also on perusal report, it is evident that the accused person is absconding in this case, and the IO has prayed for issuance of proclamation process against him, which is considered an allow issue. Writ of warrant census. Yes, where is the wrong?
So immediately after previous orders of year of document, then immediately without issuing any specific 30-day notice to the accused person.
To whom? You are warrant of arrest because several data IO has filed an application.
82 surplus 1 mandates the London magistrate to give a specific notice from the accused person, giving a 30-day clear notice to appear particular date and time that has not been cited in the issued order. Statewide, it has issued proclamation, writ of proclamation, and that too even out by delegation of judicial work to other person. There is no specific according to the order sheet that the accused person need to appear on particular date and all.
Then
then there is no publication of notice, no specific notice for appearance of clear 30 days.
Sir, what is the proclamation? What is the proclamation?
Proclamation.
If you are in warrant, several dates has been given, IO is able to arrest you.
No.
The proclamation has to be placed in your conspicuous place of your residence.
That has not been done.
Not been done where, when you are challenged, 524, this order.
25 May. In there is no reflection of that has been done.
So that is to be done after this.
After this kind, this is the next order. 31st of July.
Fixed for year of proclamation, so and so who is in court bail is present. No, one proclamation execution report against is found today, filed the absconding accused, which is per and found that proper that accepted and has not been appeared today. This court inspector. Yes, publication of the notice. Then
there is no declaration of proclaimed offender. There is no declaration of proclaimed offender. So primarily there is no notice being clearly been served. 30 days clear notice.
Who has affirmed this application?
The petitioner himself.
Okay, I direct the petitioner to present here. I direct the petitioner to present here. I am directing you. He has affirmed this application. Nah? I will direct the petitioner to present before this court and let the IO come here. I will see how the warrant is to be executed.
That is.
You are playing with the court. Warrant proclamation, now you have come with the court and file an affidavit and challenging the proclamation without appearing in the court and avoiding the proceedings.
No, don't take me, I'm sorry, I'm not avoiding the proceeding.
Then why you are not appearing? Go and surrender.
Why lordship, my humble submission within the proclamation order itself is not in accordance with law. That's why I have challenged it.
Okay,
That's
I am
why
dismissing it.
Lordship, why I am telling lordship the coordinate bench of this honorable court in the identical situation in the similar set of facts.
But I am against. I find the order, the several warrants has been issued.
There are
Proclamation
series of non-compliances.
Okay, no problem.
There is no clear notice but was given.
No problem.
Number two is that there is no declaration of the declared proclaimed offender. There is no. It is kindly see 81. Kindly see 81. 82. Sorry, 82. If any court has reason to believe whether after taking evidence or not, that any person against whom a warrant has been issued by it has absconded or is concealing himself, so that such warrant cannot be executed. Such court may publish a written proclamation. That has not been done. Number one, proclamation requiring him to appear at a specific place and a specific time not less than 30 days for the date of publication of the notice. That particular subclause 1 has not been complied with. This is number 1.
So what is the kindly come to your order dated 21st of May?
21st of May, yes. 21st of May, then issue warrants, reach of proclamation against the accused person so and so, send the same to IO for execution, bench office to comply. So, and then executing officer must ensure the execution of proclamation by way of affixing is done strictly as per 82 of the CRPC, and report must contain such date of affixation, signature, mobile number of the witness, the copy of the relevant GDE lodged after execution at the local PS of the the place of residence of warranty must be accompanied with such report. Today, one more prayer is received from IO, which pertains to the destruction of the seized drugs of the case. That the said prayer is allowed. The IO is directed to contact the drug disposal committee for destruction of the seized mother drug of the case. Let the copy of the order be sent along with the proclamation read to be onto the contract.
The writ was issued.
So read was issued, but there is no specific notice.
So notice the IO will when it will posted.
I got recorded that notice in date been issued, giving it here 30 days. I have to apply before the director.
Sir, court has issued the proclamation when the date is fixed, 31st July.
Yes.
So when the proclamation will pasted, it will be mentioned which date.
That
okay.
Lordship, that notice was not given to me.
Record a notice.
Lordship, kindly. Lordship, kindly. That notice has not been given to me. It is direct. It may be directed.
Where? That's why I'm asking. Where is the further order?
Further order, Lordship. This is the.
So kindly show me this order not been complied with. Then your case can be made out.
All the order. What is available in the lower court? I have annexed all the orders. It's something to you. This is supplementary. I have all record I have put on record. Certified copy.
Where is the execution report filed by the IO? One proclamation execution report against the accused is found filed today. Where is that?
Proclamation report is not there.
So you.
See, I can best produce the certified copy of the order. All things.
Why? If the report is filed, you are the accused. You are having the wakalatam. Why you not get the certified copy of the report?
The report cannot be given.
Have you applied? Show me the certified copy of the form.
No. This certificate is not available to me.
Why?
It is not ordinarily given to the accused person at the time. Only the order sheet I am entitled to get.
Acha?
Yes.
Sir, I was there 30 years and doing these matters.
I know, Lordship, I do. But the thing is that Lordship, all records of extra certified copy, Lordship, there is nothing.
Give the CRO. Give the CRO.
Criminal rules and orders.
Give the
Criminal rules and
CRO.
orders.
I will impose cost if you will stick on this submission. You will not get the certified copy of the report if it is against the accused person. What you are mentioning?
Criminal rules and orders. Library তে হবে।
Fix tomorrow. And think in the night what you are submitting. You will not get the report. Without the report, how you can file? If in the report only you can show that the investigating officer has not given the 30 days time. Mayors are telling that the report, because the court, see, we are what the High Court or the session judge or the magistrate are passing the investigating officer to take appropriate steps. The appropriate step is to be taken by the concerned authority in terms of the law. If the proclamation was issued, the proclamation is to be publication, is to be pasted. So the IO will give the date over there, 30 days from the date of pasting this. Then he will submit, I have pasted this, 30 days is over, he has not come forward.
Yes.
Then what is telling, that's why I'm asking, where is the report? You will get, sir, because it is accused. You will get. Even I am, that's why since my first day of my sitting, I am telling you are not enclosing the 61, even 161, you are not received the copy under 207, you will get the certified copy you are having the
particularly after Supreme Court judgment.
This is a very burning issue that not the certified copy of 161 or 164 statement are not available under application for certified copy. Only the order sheet are available.
Who told you?
He has not applied, my lord.
No,
Let one such rejection come to
you
the
do one thing, you apply and get it rejected, come here.
Yes, it will take
an order. And you go through, first you go through the CRO, civil and criminal rules and orders. There is a chapter.
সাহেব কিন্তু ও দাদা কি বলছে সাহেব একদম অমিতাভ বচ্চনের মতন লাগলো শুনতে ও দাদা ভালো বলছে এই তাড়াতাড়ি কর
না কিছু করতে